Right, we will be made.
Original set mentioning is now. When we take up the original appellate set, then.
My lord, may I be permitted to grant a leave for moving an application for
appellate
stay, my lord?
No.
Appellate set we are not.
When I move, my lord.
Original side. আরে তারা বললেন
Yes.
My lord, I've mentioned this matter, my lord, last Wednesday.
Original set.
Yes, your original side, my lord. This was supposed to come today. My lord, the entire matter will go infructuous.
Regular
Well, I've
officer is not there. That's the difficulty.
my lord, I've already indicated my other side. I've given notice that I will mention it today for listing the matter in the supplementary list. I've also given the notice that the matter will be taken up today.
আসেনি কেন এটা? Direction তো দিয়েছিলাম কত সপ্তাহ?
There was a leave to my lord.
Yes, yes. কি জন্য আসেনি? তাহলে দরকার সাপ্লিমেন্টারি লিস্ট পার করে একটা সময় দিয়ে দাও। If the papers come, we are
The
trying
files have come, my lord. Yesterday I've checked.
in the court. তাহলে ইয়ে করে দাও। তুমি 12টার সময় ওটা একটার সময় ইয়ে করে দাও। সাপ্লিমেন্টারি লিস্ট পার করে দাও। Tell the other
I'll
side
give one more notice, my lord.
from that we'll try to put it in the supplementary list today at 1. Give a notice.
I'll give a notice, my lord. I'll try to call them and contact us. Grateful.
এরম যেন না হয় অঙ্কুর একটু খেয়াল রাখতে হবে। কল কর।
না 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 এখন নয়।
When we take up the appellate set matters, yes. Call on the list.
মালা ভাই order 49 rule 11 ভাই।
আরে অর্ডার 14 রুট বসাই এখন
This is not for releasing, my lord.
কি ম্যাটার এটা?
This is
Yes. Why you
Essential Commodities Act, my matter, my lord.
don't have determination? Yes. Since this court does not have.
But only one prayer, my lord. Your lordship directed us to file paper book, my lord. It is ready. Whether
No, file it. Since this court does not have determination now to take up the matter, let the matter go out of the list with liberty to the parties to move the Honorable the Acting Chief Justice for having it assigned before the. Sorry.
it is come in regular.
In view of lack of determination, let the matter go out of the list with liberty to the parties to mention for inclusion in the list before the bench having determination. Give the appearance. 10:30.
Item number 4.
Item 10:30. Yes.
Yes, 45. Yes, my lords. Because I propose to be very, very brief today and try and wind up very, very quickly.
Thank you.
And therefore, we'll just make a few broad points. My lords, the first point I wish to make is regarding, my lords, the issue of control. Because in my respectful submission, exercise of control is not a necessary concomitant of an affiliate party relationship. In other words, for the purposes of entry 2 and other entries, it is not necessary that a relationship of affiliate will only exist if either the party exercises control over the affiliate or vice versa, the affiliate exercises control over the party. Now, my lords, I had made good this argument by referring to a few points in my earlier written note. And those points were that the guidelines had been made by a set of international practitioners. Now, certainly, the Indian test of control under the Companies Act, which is section 2(27), was not in their mind. So to import the Indian test of control into the IBA guidelines will actually run counterintuitive to the whole spirit of the guidelines. Second submission was that wherever the guidelines or the schedule entries specifically wish to refer to control, they have specifically used the word control. So that is entry numbers 5 and 9. They specifically use the word control. And submission number 3 was that if control is to be read in any entry, some of the entries may become unworkable. For example, entry number 5 is an example that I had given, because that presumes that the arbitrator will have control. So if affiliate already, as per the submission made, is an entity under control of a party, then an arbitrator can't have a double control over the same entity. So those were the broad submissions I had made on control. Now, my second limb of submissions is that in any case, insofar as group companies are concerned, again, there's a separate independent submission. Insofar as group companies are concerned, there again, control is not a mandatory requirement. As per the definition of group companies, which I am referring from Cox and Kings, it is not necessary that the group companies should be under control of each other, or there should be a parent which should control all the group companies. Now, my learned senior Mr. Mukherjee referred to 3 cases: ArcelorMittal, Vodafone, and Birla. 3 cases were relied upon, and broadly speaking, the principle which was sought to be made good was again on control. But in my respectful submission, these cases turn on their own facts. So one will have to actually check the context in which the Honorable Supreme Court made the relevant findings. Birla, of course, a decision by this Honorable Court. ArcelorMittal, the issue was of Section 29A of the IBC. The Supreme Court was confronted with an issue as to how to interpret Section 29A(1)(c). And in that context, where the word control is explicitly referred in 21A(1)(c), the word control is referred. I will just read that decision just in 2 seconds. Likewise, in Vodafone, the issue was one of capital gains arising or potentially arising out of a transfer of securities which took place outside India. So in that context, the Supreme Court made some observations regarding a subsidiary-parent relationship and the fact that a subsidiary has a distinct legal personality from the parent company. I am not disputing any of the propositions. All that I'm saying is that your lordships are today not concerned with a case under the Companies Act or under the Securities Act. Your lordships are today hearing a case under the Arbitration and Conciliation Act and in relation to specifically interpretation of certain entries. To import, again, I'm repeating myself, again, to import the strict definition of control under Indian law while interpreting the entries may not be an apposite exercise. Now, my third submission is that as a matter of fact, now I'm saying without prejudice to my first 2 submissions, in my respectful submission, indeed in this case, the facts suggest that late Mr. Bhaiya indeed had control over SSSMIL. So that's a submission on fact that assuming your lordships were to hold against me, I'm saying there was control. And the control was there, one, because of the shareholding of almost 36% by the promoter and promoter group over SSSMIL. The fact that the board of SSSMIL at the relevant point of time constituted the daughter, the son-in-law, and 1 employee of CNE. All of the registered office was common. All of these facts, and I'm not repeating those facts, those are covered in my note. All of these facts cumulatively suggest that there was a de facto exercise of control over SSSMIL by late Mr. Bhaiya. So that's my third submission on control. Now, I am not going to get into the relevant paragraphs of Vodafone and Birla. I am indeed not disputing those propositions of law, but those are, as I said, those are in the context of the issue before the court. But yes, indeed, I just want to quickly refer to ArcelorMittal once, because that I believe has something which may favor us. The ArcelorMittal, a copy had been given to your lordships by
Yes.
Yes, your lordships may come to first page 42, para 26. Paragraph 26 extracts section 29A. And that was the proviso which came up for consideration. Because your lordship will kindly see 29A(c). At the time of submission of the, may I just read the full thing? A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. Now I'm reading C. At the time of submission of the resolution plan has an account or an account of a corporate debtor under the management or control of such person. Supreme Court said we will interpret the word management or control. Now that exercise first starts at paragraph number 29. where the Supreme Court says that while interpreting 29A1C, we will have regard to the object of section 29A, namely to keep certain people out from submission of resolution plan. So paragraph 30, my lord, says purposive interpretation of 29A, depending both on the text and the context in which the provision was enacted, must therefore inform our interpretation. Now, my lords, kindly come to paragraph 32. Opening lines of 29A of the Amendment Act refer to de facto. Actually, it should be 29AC. That's a typographical error in my respectful submission. And that will become clear from para 59. But anyhow, opening lines of 29A of the Amendment Act refer to de facto as opposed to de jure position of the person mentioned therein. This is a typical instance of a see-through provision, so that one is able to arrive at persons who are actually in control, whether jointly or in concert with other persons. Wooden literal interpretation would obviously not permit a tearing of the corporate veil when it comes to the person whose eligibility is to be gone into. However, a purposeful and contextual interpretation, such as the felt necessity of interpretation, alone governs. Now, let us kindly skip all of this, and your lordship, my lords, will now come. I am skipping some case laws, etc., on lifting of corporate veil, and straight away paragraph 37. The Supreme Court concludes by saying on this part of the discussion, and paragraph 37, it is thus clear that where a statute itself lifts the corporate veil, or where protection of public interests of paramount importance, or where a company has been formed to evade the obligations imposed by law, court will disregard the corporate veil. This principle is applied even to group companies, so that one is able to look at the economic entity of the group as a whole. Now, your lordship, my lords, will now, let's come to paragraph 47. And paragraphs 47 to 51 have been read by Mr. Mukherjee. But may I just, my lords, give it a different spin, if I can use that word. Now, my lords, 47 first. Ingredients of clause C, lordships has, my lords? Yes.
Yes.
Are that the ineligibility to submit a resolution plan attaches if any person, as is referred to in the opening lines of 29A, either itself has an account or is a promoter of, or in the management or control of a corporate debtor which has an account, which account has been classified as an NPA for a period of at least 1 year from the date of such classification till the date of commencement of the CIRP process. For the purpose of applying this subsection, any one of the three things which are disjunctive needs to be established. Corporate debtor may be under the management of the person. Corporate debtor may be a person under the control of such person, or the corporate debtor may be a person of whom such person is a promoter. Now, 48 is the first element of management. Expression management would refer to the de jure management of a corporate debtor. The de jure management of a corporate debtor would ordinarily vest in the board of directors. Now, paragraph 49 is the second element of control, which is references to section 2(27) of the Companies Act. And may I now read 50. Expression control is therefore defined in two parts. First part refers to de jure control, which includes a right to appoint a majority of directors of a company. Second part refers to de facto control. So long as a person or persons acting in concert directly or indirectly can positively influence, and much emphasis was paid to the word positively influence, in any manner, management or policy decisions, they could be said to be in control.
Mr. Dewan, you say these tests cannot be adopted in respect of the arbitration.
Correct. The only point
that control is not used at all.
Yes.
Where it has been intended to be used, it has been used in some of them.
Correct. I'm grateful. So the only limited point I wish to make was
this exercise was in that context, IBC context.
But the only point your lordship will note for my argument is
even
for control, the definition of control has two parts, as the Supreme Court says: de jure control and de facto control. Now, de facto control, the relevant line is at the bottom of the page 62. Just only 2-3 lines I want to read.
Please.
So long as your lordship has the last line of page 62. So long as management or policy decisions can be or are in fact taken by virtue of shareholding, management rights, shareholder agreements, voting agreements, or otherwise, control can be said to exist. Thus, the expression control in 29AC denotes only positive control, which means that mere power to block special resolutions of a company cannot amount to control. Control here, as contrasted with management, means de facto control of actual management or policy decisions that can be or are in fact taken. Now, Mr. Mukherjee's argument was that when we talk about control, and he says ArcelorMittal clarifies that position, it must be a positive control, which means that only a negative control is not control. You must have positive control. Now, in my respectful submission, there is indeed, in this case, a positive control over SSSMIL by late Shri BD Bhaiya, which, my lords, comes out from the fact that the shareholding was over 25%. Now, my lords, may I refer your lordships to the Achuthan committee report, and that was part of the compilation that I had handed over, my lords, previously. Compilation they did. Case law compilation.
ওদের compilation, respondent compilation to see that. Different.
Oh, I see. First volume of the case law compilation that we had filed. In fact, the very first document of that compilation. Yes. Yeah. Plus, page 2 is the cover page of the report of the Takeover Regulations Advisory Committee under the chairmanship of Mr. C. Achuthan. It's popularly called the Achuthan Committee report. Now, your lordship recollects SSSMIL was a listed company, or is rather a listed company, was also a listed company at the relevant point of time. Now, your lordship will see the relevant page is page number 25. Paragraph 2.1. Well, may I read this?
Yes, please.
Yes. So current provision that the committee is now deliberating about the existing provisions and whether to revise them. So the current provision, under the heading current provision, takeover regulations currently provide that if an acquirer acquires or agrees to acquire shares of voting rights such that his voting rights exceed 15% of the voting capital of target company, he is required to make an open offer. Now, let's kindly turn over the page at page number 26 and please see paragraph 2.6 and 2.7. It was observed that despite the increase in the mean level of promoter shareholding, there are a number of prominent companies in India which are controlled by shareholders holding between 25% and 30% of the voting capital of the company. Committee is of the view that this trend suggests that 25% is the level at which promoters would be capable of exercising de facto control. Further, in India, Companies Act recognizes any holding in excess of 25% as the threshold at which special resolutions can be blocked, taking into account both the ability of promoters to exercise de facto control at 25% and the law governing special resolutions. 30% threshold would be too high. Committee felt that 25% shareholding would be an appropriate level at which a new incumbent shareholder could reasonably expect to exercise positive control in the current environment. Thus, the committee concluded, since a holding level of 25% permits itself de facto control of a company, this could be fixed as the appropriate open offer trigger threshold in the Indian context. And indeed, now the requirement is 25% alone. And this is in recognition of the fact that insofar as a listed company is concerned, the moment someone has 25% or more, there is a deemed presumption, let me use that word, there is a deemed presumption that the person can exercise positive control over the company. Now, this would become even stronger in the case of SSSMIL because there is one company, one corporate entity, that gas entity, which is owning about 26%, BG Chemicals, and the other are individuals, promoter block together holding some 36%, and the rest are public shareholders. So when contrasted with public shareholders, in this case, even if control is held to be an element of any of the definitions of affiliate, I would say the test of control is fulfilled. Now, two other small balance points. Because would your lordship be so kind to turn back to the written note that I tendered? my lords, which had paragraph 28 onwards. Your lordship remembers there was this note had two parts. Some pages were replaced. So I'm now looking at the second part, which starts with page 8 onwards to be replaced, para 28.
Hello? Is this the one which starts with the first one or page 8 onwards?
Page 8 onwards. I had read a lot of it on the last date, the facts, etc. I just want to read 4 more paragraphs, the balanced paragraphs. Your lordship, my lords, kindly turn to paragraph 33. Lords, now may I read, my lords? Such representation for SSSMIL also falls foul of the initial disclosure provided by the learned arbitrator to the parties on 10th of August 2014, where his appearance for BDB or companies managed or controlled by him was regarded as giving rise to justifiable doubts as to his independence and impartiality. Now, my lords, may I stop here? Your lordship, my lords, my argument on the initial representation was that the fact that the learned arbitrator in the beginning of the arbitration proceedings gave a disclosure that I have previously, some years, a number of years back, appeared for companies owned or controlled, owned and managed was the expression for late Shri B.D. Bhaiya, that the fact that such a disclosure was given shows that a benchmark was there, that if there is in future any further representation, that would go against the very benchmark that the learned arbitrator had fixed in the initial hearing. Your lordship had also put the same question to my learned senior, Mr. Mukherjee. Mr. Mukherjee's answer to this question was threefold. He said first that the disclosure was given in subjective satisfaction by the learned arbitrator, in his subjective satisfaction. The second answer was that after amendment, one has to go by the text of the statute. So the law has changed. This was given prior to the amendment. Now one would only look at the statute. You don't need to look at the prior disclosure. And the third answer was that the disclosure doesn't specifically say that the learned arbitrator had appeared for SSSMIL. So while there is a disclosure, and your lordship will perhaps, may I just take your lordship back to the disclosure, if your lordships don't mind. Volume, this is volume 2, page 200 and, volume 2, there's no page number. This should be page number 44.
Page 139 থেকে শুরু তো, page number 44 বলছি।
Oh, I'm sorry, volume 2, page 172. I'm so sorry. So 171 is the first minutes. Your lordship has read this now a large number of times, but perhaps for the one last time, page 172, paragraph 2.1.
Yes.
At the outset, the arbitrator informed the parties that he had professionally been engaged several years ago as counsel to appear for Mr. Bulaki Das Bhaiya, one of the claimants in the proceedings, or by companies within his management and control in certain earlier legal proceedings, with regard to which Shri Bhaiya had attended the conferences and had occasion to confer with and meet the arbitrator. Arbitrator further informed the parties that his son had apparently also appeared for the claimants, etc. So the argument was that while it talks about companies within the management and control, but there is no company which is named. So therefore the disclosure doesn't really talk about having appeared for SSSMIL in the past. So that was the argument to meet my argument that this is really the benchmark. If the learned arbitrator decided to appear again in future, despite the disclosure, that will be going against the benchmark. So three answers were given. Now, my response to this is twofold. My first is that as on the day when the disclosure was given, the unamended section 12 prevailed, as per which a disclosure was warranted when there were justifiable doubts as to independence and impartiality. So according to me, the fact that the learned arbitrator gave a disclosure can only show that in his mind, he felt the need to disclose because there was justifiable doubt on his independence and impartiality. The amendment of 2015 has not changed the position. 12(1)(a) still uses the word justifiable doubts as to independence and impartiality. The only change which has happened post 2015 is that there are now two schedules, Schedule 5 and Schedule 7. Schedule 5 is only to operate as a guide in determining whether there is a justifiable doubt as to independence or impartiality. And Schedule 7 is an absolute bar that makes you ineligible. So in my respectful submission, if in 2014 at the time of disclosure, it was felt that there was a justifiable doubt as to independence or impartiality, that does not change post-amendment.
Mr. Diwan, do you say that the schedules are only a guide, and if there is some situation which falls outside the schedules 5 or 7,
yes,
then also we can take note of that?
Manoj, that's my argument, yes.
Even after the amendment?
Even after the amendment. And
Let us see the language of section 12.
Yes, kindly see, Manoj. Kindly see 12.
How it refers to 5 and 7.
Yes. In fact, there is a direct judgment in my submission on this point also, but kindly first see 12.
Yes.
12(1). When a 12(1), when a person is approached in connection with this possible appointment, he shall disclose in writing.
Shall guide.
Yes, shall guide.
Expression 1 is there, shall guide.
Correct. So ground stated in the 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality. There could be other circumstances also. 7 may be exhaustive, because I don't want to stretch this beyond a point. 7, insofar as Schedule 7 is concerned, Schedule 7, either the arbitrator is falling within those items or he's not falling within those items. So a party cannot say, or party cannot perhaps be heard to say, that even if the case is not within 7, you should disqualify under 7. But insofar as there could be a catena of other situations not falling within 7, which on a case-to-case basis, your lordship will have to see whether those cases raise an element of justifiable doubt. So 7 is, in that sense, in my submission, the entries are there as a complete code, but plus there could be other circumstances also, which is why your lordship will notice that 7 has about 19 entries and 5 has about 30 odd entries. The relevance of the balance entries in Schedule 5 is that those also lead to those also indicate a justifiable doubt. If, however, the court feels that there is a reasonable basis for harboring that doubt, the court can still exercise the power and terminate the mandate of the arbitrator. Because I hope I'm clear here.
We'll just read 5, subsection 5 of 12.
Yes.
Yes, you may have a point there, because it does not say that 7th schedule is exclusive. Notwithstanding any parity, etc., if any person, his relationship falls under 7th schedule, then he shall be.
So he's short out. Let's put it like this, my lord. If you are in 7,
shut out. You're shut out.
But does not mean that there cannot be any other circumstance. Which is why, because if 7 was to be only exhaustive, then what is the point of entry numbers 20 to 34 in 5th schedule? Because those entries also lead to a justifiable doubt on the independence and impartiality of an arbitrator. The only difference is that I will have the onus to establish a court.
Ineligibility is a higher ground.
Yes.
You are ineligible at the outset.
Correct. So 7, if you are in 7, you are out. For any other entry, which is balance entry numbers 20 to 34, I will have to, or the party approaching the court will have to make out a case. The court will have to see, considering all circumstances, whether the justifiable doubt as to independence and impartiality exists, does not exist, and then make a case-wise ruling.
All right.
So that in my respect, and that will perhaps come out of a paragraph also of one judgment, as I'm just going to shortly show.
Yes, it doesn't. 12.5 doesn't exclude other grounds.
It doesn't exclude.
Even for ineligibility.
Yes.
If you are under 7th schedule, then you're gone.
You're gone.
But it does not say that. It does not mean that other grounds cannot come in.
Absolutely. Absolutely.
Those are
because-
absolute bars. If
and
you use
Lordship
the
will
expression.
keep in mind that this is all a borrow. We have all borrowed this from IBA. IBA itself says these are non-exhaustive. So the IBA was general principles have to be kept in mind. These are some illustrations we are giving for practical solutions, for practical situations. That's the whole idea. So the prevailing text is the general principles. These are application in I would say practical situations which may arise. So those are only have been given in the code. So Manoj, my first point insofar as this initial disclosure was concerned is that the so-called change in law doesn't mean that the benchmark has changed. But more importantly, Manoj, after this point was made, my colleagues here in Delhi, we took a deep dive of the pleadings again. And we have discovered that the disclosure actually was referring to SSSMIL only. And may I show that page to your lordships now? Manoj, that's volume 12, page 1. No, the relevant, it starts at 1494, volume 12, page 1494. It starts at 1494. This is the affidavit in opposition to my section 36 application. Your Lordship has 1494.
Yes.
So this is where the application, the affidavit in opposition to my 36 begins. And now kindly look at the relevant paragraph. It was at 1516 bottom. Your Lordship will find paragraph number 25.
Yes.
May I just read this? Save what are matters of record, what will appear from the Arbitration Act. Allegations made in 21 of the said petition are denied and disputed. Denied that learned arbitrator had continued to appear for respondent number 2 or companies owned, managed or controlled by him in other legal proceedings after the commencement during the continuance of the arbitration. Denied that learned arbitrator appeared as counsel for any of the parties, as well as denied that de jure de facto. And just look at the last line. I state that the learned arbitrator had already disclosed that he had dealt with SSSMIL at the outset of the arbitration proceedings, and as such, it is denied that it is incumbent on him to make any other disclosure of the same fact again. So the understanding of the appellant is that the initial disclosure, which talks about companies owned and managed by late Mr. B.D. Bhaya, was a reference to SSSMIL. And that leads, Manoj, to 2 points. One, that this statement itself shows that SSSMIL was under the ownership and management of late B.D. Bhaya. That's the word used in the disclosure. Companies owned and managed. And Manoj, if the other important point is that if the learned arbitrator initially said that I had long back appeared for SSSMIL and that gave to a justifiable doubt, the fact that he appeared for SSSMIL at a later point of time shows that he has unfortunately breached his own disclosure that he had given. So in my respectful submission, this is a very, very strong pointer to the fact that there has been a violation of section 12 read with the initial disclosure made by the learned arbitrator. Because the expectation at the relevant point of time was that I'd appeared long back. So I'm telling the parties now. But if you end up appearing for the very same party again, then that in my respectful submission would be the end of the matter. Correct. And yes, my friend is right. There is also a violation of 12 too, because a continual disclosure had to be made and there was no continual disclosure which was made. Now, let's kindly come back to my note. It's paragraph 34. May I just quickly now?
We will be requiring volume 12.
No. I am now done with everything. Only a few, maybe 5-10 minutes more. That's it.
Yes.
Maybe one other fact that I would like to show, but that's not from volume 12.
Yes.
Well, it's paragraph 34.
34.
The fact that learned arbitrator did not even give a disclosure under entry 2 of 5th schedule is a circumstance which should weigh against the award. General standard 3D of the IBA guidelines provide that in case of any doubt on whether certain facts or circumstances should be disclosed. Such doubt should be resolved in favor of disclosure. General Standard 70 ought also to be taken into account, which provides that an arbitrator under a duty to perform reasonable inquiries to identify any potential conflict of interest. Facts on record disclosed, name Chemcrown India Private Limited, came up several times in the pleadings and evidence of the parties. Indeed, paragraph 3.4 of the award refers to the fact that BDB had formed Chemcrown. These facts should have put the learned arbitrator to notice. Learned arbitrator ought to have conducted reasonable inquiries before deciding to represent SSSMIL. Failure to do so is a circumstance which leans against the validity of the award. Legally trained mind, such as that of the learned arbitrator, ought not to have placed himself in a situation which, apart from acting in dissonance with entry 2 of 7 schedule, read with 12.5, also gave rise to a reasonable apprehension of bias against him. Now, please omit 36 is a point I've already made. 37. The invalidation of the award is also attributable to the appellants and their counsel who instructed the learned arbitrator in APD 252 on behalf of SSSMIL, an affiliate of CNE. Conduct of the appellants is against the tenets of General Standard number 7, duty of parties and arbitrator of the IBA guidelines on conflict of interest in international arbitration, which impose a duty on parties at the earliest opportunity to inform both the arbitrator and the other parties of any relationship between the parties and the arbitrator. So in my respectful submission, there was perhaps in my respectful submission a fault on the part of the arbitrator, but there was also equally, if not more, the fault on the party concerned. You are there, same lawyers, and the same arbitrator is now being engaged for 11 appearances in a matter on behalf of SSSMIL that should perhaps not have been done. And this is also a little curious because in the grounds of appeal, which your lordship will note now, at Muller's volume 13, page 1622, is where the appeal, this current appeal, starts, this present appeal.
Yes.
And your lordship will only note one ground V at 1625, the very next page. For that, the learned single judge failed to appreciate that the appellants were not at fault in any manner whatsoever and ought not to suffer prejudice on the basis of any technical fault of the learned arbitrator. Plus, firstly, violation of 12 or the schedules can hardly be said to be a technical fault. It's a serious matter. And secondly, for them to say that we were not at fault and the arbitrator had a technical fault, is also double speak. So the appellants, perhaps in my submission, cannot walk away from the situation that we didn't know about it and the arbitrator did some quote unquote technical fault. Now, your lordships had put that question to me about whether 7 is exhaustive, 5 is exhaustive. Perhaps there is a paragraph in a judgment called core, which may answer your lordship's question. I may just refer to that. Core. It's in the judgment compilation. So, just see what this may have, page 733. Just tell which 733 is the page number. Yeah. Volume 4? Yes. Only one paragraph, I wanted to show. Reference. Yes, it's Central Organization for Railway Electrification versus ECI SPIC SMO. Because the judgment starts at page 2025 for SCC 641. Yeah, it starts at 192. Volume 2 mein hoga.
Volume 4. Oh, achha. Sorry, it's volume.
I'm sorry.
No, you are right.
Because I have an electronic copy, so maybe I'm
No,
sorry.
you're right. You're right.
Sometimes
It's volume 2.
Okay. Now, your lordship has seen the 192 is where it starts. Now, my lords, only one paragraph, paragraph 113. At this, your lordship will find running page 284.
Yes.
May I just read 114? An arbitrator will not be automatically disqualified in situations where the relationship of an arbitrator with the parties does not fall under the categories mentioned under the 7th schedule. Yet, either of the parties may have justifiable doubts about the independence or impartiality of the arbitrator. Party challenging the appointment of an arbitrator does not need to demonstrate that the arbitrator lacks independence or impartiality. It only needs to show possible doubts as to an arbitrator's independence or impartiality. The purpose behind incorporating word justifiable under 12 was to establish an objective standard for impartiality and independence. Resultantly, the possibility of doubts must be real in the sense that they should be derived from the objective circumstance. So 7, if you are within 7, I'm sorry, then you are out. But there could be other situations also, which would then be covered by 12.1 and 12.2, about circumstances where I'm able to show that I have justifiable doubts, and the court then appreciates my submission. In the same judgment compilation, there is a judgment at page 412. Just tell the volume number. Volume 3. Vinod Bhayalal Jain. Well, 412 is the judgment. Vinod Bhayalal Jain. On the last occasion, I read it. I will not dwell much on it, spend much time on it, but your lordship may only make a note of a few paragraphs. In fact, paragraphs 9 and 10. This was a case prior to the amendment in 2015. The Supreme, and there was only one appearance in one single matter by the arbitrator as a party, not many appearances, not regular appearances. And the Supreme Court ultimately said that even though this case may not be covered by the schedules, your lordship will in fact read 9 and 10 with me. So
Yes.
in the ultimate analysis, since we are not adverting to the merits of the claim, in that regard, since we have not adverted to the finding recorded by learned arbitrator on the merits, we would not venture to examine. However, in the above background, what is to be seen is that there has been a reasonable basis for the appellant to make a claim that in the present circumstance, learned arbitrator would not be fair to them, even if not biased. It could no doubt be only a perception. Be it so, no room should be given for even such a feeling, more particularly when in the matter of arbitration, very basis is that parties get the opportunity of nominating a judge of their choice in whom they have trust and faith, unlike in a normal course of litigation, where they do not have such choice. That apart, when one is required to judge the case of another, justice should not only be done, but seem to have been done, is the bottom line. Now, for that one single appearance, that fact of one single appearance, kindly see paragraph 4 at page 414. May I read quickly paragraph 4? Respondent number 1, who was aggrieved by the same, had filed the appeal under section 37(1)(b). The appeal was against a setting aside of the award. Learned judge of the High Court, while examining this aspect of the matter, was of the opinion that the objection raised with regard to Shri so-and-so advocate acting as the arbitrator was raised by Shri Bhayalalji Jain, who is the father of the appellants herein, and not by the appellants themselves. As such, the same cannot be construed as an objection by party to the proceedings contemplated under section 13. Further, it was held merely because the learned arbitrator had appeared as a lawyer in one mean profits case for RY. Only one case. No other cases, no regular appearances, no standing counsel role, or regularly, consistently seems to have the arbitrator has appeared, but only one single appearance. And this was a case, your lordship will again make a note, this was a case, the appearance happened much prior to the amendment. This is a case of 2004 when the schedule had not even been amended. Now, my lords, one new judgment which I had not previously cited and I wish to cite today. Yes, was the judgment of the Supreme Court in Sundaram Pillai. Oh, I can't find my own decision. Very good. I have it. Yes. But Sundaram Pillai, the only reason I'm citing so is I thought that the judgment sheds light on the explanation. When there is an explanation to a statute, how that explanation, because in our statute there is an explanation, affiliate. Yes. Now your lordship will first, my lords, see the legal question at my lords, just see the page number of this one. Page, it should be page 9. No, page 9. Page 9. Yes, page 9, where the honorable judge's name is given. And this, my lords, is on behalf, the judgment majority was by Justice Murtazala Fazal Ali and Vardarajan J. And, my lords, one of the judges had dissented in the matter. So I am reading the majority opinion. Let's kindly just see the issue involved. May I read that, my lords, first paragraph? These appeals involve more or less an identical. Lordship has that? Yes, I'm sorry. These appeals involve more or less an identical point of law relating to the interpretation of the term willful default appearing in the proviso to section 10(2) of the Tamil Nadu Buildings, Lease and Rent Control Act, coupled with the explanation which seeks to explain the intent of the proviso. We have heard counsel, etc., large number of authorities. That's the legal issue. They wish to interpret. The court was interpreting the expression willful default coming in the proviso and what is the impact of the explanation. Now, your lordship, my lords, will see the proviso first. The proviso in question comes at page number 15, bottom, as a part of paragraph number 19. May I read the proviso? Provided that in any case falling under clause 1, if the controller is satisfied that the tenant's default to pay or tender rent was not willful, he may, notwithstanding anything contained in section 11, give the tenant a reasonable time, not exceeding 15 days, to pay or tender the rent due by him to the landlord up to the date of such payment or tender. On such payment or tender, the application shall be rejected. And now comes the explanation, which your lordship will find at page number 22, paragraph 45. So the explanation now inserted by of the Amendment Act was, your lordship has para 45. For the purpose of this subsection, default to pay or tender rent shall be construed as willful if the default by the tenant in the payment of tender of rent continues after the issue of 2 months' notice by the landlord claiming the rent. So the explanation was qualifying the proviso. Just, my lords, kindly notice the argument made before the Supreme Court at page 16, paragraph 20. Yes. This proviso was clarified by an explanation added to it by Act 23 of 1973, which provides a clear criterion to determine as to what is willful default and what is not. In this connection, it was submitted by counsel for tenants that despite the explanation, it is open to the court on an appraisement of the circumstances of each case to determine whether or not the default was willful. In doing so, it cannot be guided wholly and solely by the explanation, which is merely clarificatory in nature. If the court in the circumstances of each case finds that default is not willful, then it can come to this finding despite the explanation. On the other hand, argument of the counsel for landlords is that the very purpose of the explanation is to bring about uniformity in court decisions by laying down a conclusive yardstick in the shape of the explanation, which says that a default would only be willful, only if the landlord gives 2 months notice to the tenant. Tenant does not pay the rent after expiry of this period. In other words, argument seems to be that the explanation is to be read into the provision so that the word willful will have to be defined and interpreted in accordance with the criterion laid down by the said explanation, issue of 2 months notice. Now, may I stop here? There is some semblance or resemblance to our case. The argument is explanation says affiliate. It either you are an affiliate as per the explanation, the explanation is exhaustive, it only contemplates companies. Read in the explanation into the entries. That's the argument of the landlords. If I may just say so, Mr. Mukherjee appears for the landlords, and his argument is, please read in the explanation in the main body. And the tenants, I'm appearing for the tenants, I'm saying, no, your lordships can independently find out whether there is an affiliate or not. Now, please see the Supreme Court's ultimate view, and I'm just not wasting time on reading everything. But the Supreme Court says at page 29, as a part of paragraph 63, your lordship will find in the middle of the page 1 and 2. That's the view of the Supreme Court. On the proviso read with explanation. And before this, the paragraphs which I have not read are where the Supreme Court gets into what is a proviso, what is the explanation. But the ultimate view, one, we express our view in the matter in the following terms, where no notice is given by the landlord in terms of the explanation. Page number 29.
Para 63.
Part of 663. Where no notice is given by the landlord in terms of the explanation, the controller, having regard to the 4 conditions spelled out by us, has the undoubted discretion to examine the question as to whether or not the default committed by the tenant is willful. If he feels that any of the conditions mentioned by us is lacking, or that the default was due to some unforeseen circumstance, he may give the tenant a chance of locus penitentiae by giving a reasonable time, which the statute puts at 15 days. If within that time tenant pays the rent, application for ejectment would have to be rejected. If the landlord chooses to give 2 months notice to the tenant to clear up the dues, tenant does not pay the dues within the stipulated time of the notice, controller would have no discretion to decide the question of willful default, because such a conduct of the tenant would itself be presumed to be willful default unless he shows he was prevented by sufficient cause or circumstances beyond his control in honoring the notice sent by the landlord. Let's kindly turn over to the next page, page 30. There is a view on top of the page by the Madras High Court by Justice Ratnam, and it's in parentheses, it's in quotes. Reading of the explanation indicates it is not exhaustive of all cases of willful default, specifies only one instance where the default should be construed as willful. If a tenant does not pay the rents at all for a considerable time, landlord files a petition for an order of eviction on the basis that the tenant had committed willful default without issuing any notice. Then, in the absence of any other explanation by tenant, default should be construed as willful in spite of the fact landlord had not chosen to issue a notice in so and so. And 65, we feel ourselves in complete agreement with the view taken by the learned judge on the interpretation of the proviso read with the explanation. So sometimes even when there is an explanation which seems to suggest that it's only when you send it will be proved, it will be established a willful default if after notice 2 months the rent is not paid within 2 months, the Supreme Court says that may not be so. That could, in my respectful submission, one will have to read the whole statute just to ascribe a definitional role to the explanation, as perhaps is the argument. My argument is no. My argument is further perhaps buttressed by the fact that our explanation says encompasses. So, those are really my submissions. And maybe one fact we came to know, it's not on record, is that even till date, the website of CNE, it's not on record, but I'm just only oralizing it, your lordship may choose to ignore, mentions that CNE is a part of a family-run Chem Crown group. That's even today, that's the case. That's on record. No, it's not on record. And this is my last point really. One of the arguments my learned senior made was that the learned single judge was hearing section 36 application, and in that course of action, section 34 was also heard. And I believe there was some objection to that approach, at least in oral arguments that was taken, that if the court was only hearing the issue of stay on the award, where was the issue of perhaps hearing the 34 on merits? That's not the argument.
That was not.
Okay, then I'm sorry. Maybe I sort of misheard that or misunderstood that. But those are my submissions. Nothing else from my side. I'm very, very grateful.
The question was raised by Mr. Mukherjee regarding the court assuming jurisdiction under section 34 and deciding.
So exercise of jurisdiction is a separate issue, but maybe I misheard it. Maybe I thought that there was some objection to the course of action adopted by the learned single judge in disposing both of them together. If that's the argument, then my answer is very simple. If an issue goes to the root of jurisdiction, any judge is entitled to hear both 36 and 34 together. Like in this case, the issue was whether the award should be stayed or not. During the course of hearing, it was realized that the main issue is regarding violation of section 12. So there is no infirmity. Plus, more importantly, no challenge was made to that course of action. There is an order of 14th of March 2023 by the learned judge. Where he says that I will hear the preliminary issue together, and no appeal seems to have been filed. I think both parties were ad idem that this would be the most fair way of concluding the matter. So today, at this stage, to take an objection.
We always do that. If there's a section 34 and the section 36.
Correct.
We take up the.
If both of them can be disposed of together on one narrow issue, then that will be in the fitness of things to do that. Because those are all my submissions, and I'm very, very grateful for a hearing.
Thank you. Thank you for being brief. Yes. sir.
Now, my lord, যে কাগজটা আপনি বলেছিলাম ছপে পাঠিয়েছে
এই যে এগুলো আপাতত
আরে
কোথায়
আজ
অবস্থা?
নিশ্চয়ই দেখো।
এগুলো তো লাগবে এগুলো yes.
Yes, my lord, your lordship's my lord given us a lot of time, my lord. I'll just, my lord, do it point-wise because your lordship's also asked for a note, my lord, of submissions. So, my lord, the first issue, my lord, which arises here is, my lord, section 12(1), on the date of the arbitral tribunal making its disclosure, and, my lord, then the subsequent amendment of 2015, whether, my lord, it has any impact or not. So, my lord, there, my lord, I wish to draw your lordship's attention again, my lord, to, my lord, the act. My lord, kindly have a look, my lord, at section 12 once, my lord.
Yes.
Section 12(1), my lord, before, my lord, its amendment, your lordships had the footnote. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence or impartiality. My lord, this is wholly subjective. That was my first submission before your lordship, my lord. And, my lord, the second thing is, my lord, it has to, my lord, any circumstances likely to give rise to. Then, my lord, comes the amendment. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing, again, my lord, it's any circumstances, then, my lord, such as existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. And, my lord, B doesn't apply. Kindly now come to, my lord, explanation 1.
Yes.
The grounds stated in the 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubt as to independence or impartiality of an arbitrator. So, my lord, there is, my lord, an element, my lord, of, my lord, if I may use the expression, objectiveness, my lord, which is coming in. My lord, statute itself, my lord, is providing a guide as to, my lord, what kind of relationships can give rise to, my lord, a justifiable. My lord, earlier it was purely subjective. My lord, this is now providing, my lord, a guide. Now, my lord, the time period which your lordships, my lord, have to look at, my lord, is of 2018, which is after the amendment. My lord, whether, my lord, there, my lord, a disclosure had to be made. That's the first submission. My lord, we've, my lord, expounded on this, my lord, that is different, etc. My lord, and my lord, that disclosure, my lord, need not have been made. But this is the first thing, my lord, I point out. My lord, the area which has to be looked at. Now, my lord, the second thing is, my lord, your lordship seen, the learned single judge has proceeded solely on violation of, my lord, the schedules. That, my lord, there has been, my lord, an infraction of the schedules. And, my lord, really, my lord, my learned friend, my lord, has, my lord, harped on, my lord, entry 2 of, my lord, schedule 5. Now, my lord, I have made my submissions, my lord, apropos that. But what is important, my lord, is the explanation here are not, my lord, clarifications. My lord, that, my lord, it, my lord, is part of the statute explaining, my lord, the term, my lord, where, my lord, it is close family member, where, my lord, it's an affiliate. And, my lord, also says, my lord, that where, my lord, there's a specialized field, my lord, those factors have also to be kept in mind. Like maritime, my lord, there are very few, my lord, from the pool of arbitrators, my lord. Those have to be kept in mind. My lord, this is, my lord, the position. Now, my lord, the test then, my lord, has to be to, my lord, determine, my lord, whether, my lord, this schedule and the entries in the schedule, my lord, have been, my lord, violated. Or, my lord, there has been an infraction, my lord, of, my lord, any of these. And my respectful submission, where we really draw a line, my lord, really, my lord, go apart, my lord, in our submissions, Mr. Diwan and me, my lord, is, my lord, with regard to, my lord, the meaning of the term affiliate. Is it, my lord, confined to only, my lord, what has been stated, my lord, in the explanation? Or, my lord, it is really, my lord, and giving, my lord, an example. It is a non-exhaustive, my lord, definition. My lord, it's inclusive, so to say, my lord, that, my lord, otherwise, my lord, affiliates, my lord, and, my lord, both of us have made, my lord, every endeavor to show, my lord, that, my lord, in interpreting, my lord, the, my lord, schedule, my lord, affiliate, my lord, according to him, my lord, will cover, my lord, all relationships. It need not be confined to, my lord, corporates. And my respectful submission before your lordships have been, my lord, that, my lord, we must look at the word party, not just affiliate. And, my lord, where, my lord, would a party have an affiliate? Which party would have an affiliate, my lord, is, my lord, determined, my lord, by the explanation. This is very evident, my lord, from, my lord, the headings themselves, my lord. Kindly have a look at arbitrator's relationship with parties or counsel. My lord, that's the first one.
Yes.
So, my lord, my respectful submission had been the arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. So, my lord, where, my lord, there is, my lord, a company and an individual, if, my lord, he advises or represents any one of them, my lord, he is, my lord, clearly, my lord, disqualified. Similarly, my lord, when, my lord, we are talking of a party with an affiliate or affiliate of one of the parties, party there, my lord, has to be, that's my respectful submission, a company. And, my lord, I had placed, my lord, the other entries or, my lord, clauses, my lord, to support my submission, my lord, in this regard. So, my lord, we can really, my lord, go on and on this, my lord. Your lordships, my lord, will ultimately have to decide this. No, those are, in fact, my lord, 32, 33, 34, I had point, my lord, those are, my lord, very clear. But, my lord, my learned friend, my lord, referred to, my lord, Cox and Kings, my lord. I just want to, my lord, deal with that. Separately. No, I have a copy. Yeah, there. My lord, kindly come to, my lord, paragraph 97. I'm sorry, my lord, 87, my lord. Page, my lord, 62 of the report.
Yes.
Now, my lord, this case, my lord, was dealing with, my lord, who would be a party to the arbitration agreement. My lord, it was concerned with that, my lord, whether, my lord, a non-signatory, my lord, subjected to, my lord,
Yes.
my lord, the arbitration agreement, and, my lord, the courts observed, my lord, that has to be determined by the intention of the parties. And, my lord, if all obligations are being undertaken by, lord, a
Group
non-signatory.
companies doctrine.
Yes, yes. Now, my lord, I only, so, my lord, really, my lord, not on the issue involved here, but since it's been cited, my lord, I want to, my lord, show your lordships, my lord, paragraph 87, 88, 92, my lord, 93. Because this is, yes, and, my lord, 109. My lord, kindly take, my lord, paragraph 87. The phenomenon of group companies is the modern reality of economic life and business organization. Group companies are a set of separate firms linked together in formal or informal structures under the control of a parent company. Lordship has that, my lord?
Yes.
Linked together in formal or informal structures under the control of a parent company. So, my lord, solar system, my lord, is being recognized here in the first sentence. The group companies can be defined in the Indian context as an agglomeration of privately held and publicly traded firms operating in different lines of business, each of which is incorporated as a separate legal entity, but which are collectively under the entrepreneurial, financial, and strategic control of a common authority, typically a family, and are linked by trust-based relationships forged around a similar persona, ethnicity, or community. A group company involving the parent and subsidiary companies is created for myriad purposes, such as limiting the liability of the parent corporation, facilitating international trade, entering into business ventures with investors, establishing domestic corporate residence, and avoiding tax liability. Then, my lord, kindly come to, my lord, para 90. My lord, I just read the first sentence. The separateness of corporate personality will be ignored by courts in exceptional situations where a company is used as a means by the members and shareholders to carry out fraud or evade tax liabilities. Then, my lord, kindly come to 91. In case of group companies, there may arise situations where a holding company completely dominates the affairs of the subsidiary company to the extent of misusing its control to avoid or conceal liability. In such situations, the courts apply the doctrine of alter ego or piercing the corporate veil to disregard corporate sins. My lord, alter ego, your lordships would recall, my lord, the other case which I had cited, my lord, of Vodafone, where, my lord, 100% shareholding or 90%, my lord, 99% is held, my lord, could it be described as, my lord, an alter ego? Then, my lord, kindly come to, my lord, para 92. My lord, Balwant Rai Saluja's case is referred to. My lord, kindly take placetum D, my lord, 4 lines above it. In the context of arbitration, the principle of piercing the corporate veil has been sparingly used because it disregards the intention of the parties by emphasizing on the overriding considerations of good faith and equity to bind the non-signatories to an arbitration agreement. Then 93. Moreover, since companies in a group have separate legal personality, the presence of common shareholders or directors cannot lead to the conclusion that the subsidiary company will be bound by the acts of the holding company. The statement or representations made by promoters or directors in their personal capacity would not bind a company. Similarly, the mere fact that the two companies have common shareholders or common board of directors will not constitute a sufficient ground to conclude that they are single economic entity. The single economic entity or single economic unit theory imposes general enterprise liability on corporate group. In DHN, Lord Denning held that a group of 3 companies should be treated as a single economic entity on the basis of 2 factors. First, the parent company owned all the shares of the subsidiary companies, that it controlled every movement of the given subsidiary company. The second, all 3 companies in the group virtually acted as partners and could not be treated separately. In fact, in DHN food distributors, what was important, was that, the asset, which was involved was being used by all the 3 companies. On that basis, concessions had been sought. Here the veil was lifted for the benefit of the companies, not, otherwise. Now, so, what I, wanted to really draw your lordship's attention to from even Cox and Kings, is, that companies are separate legal entities. They are, juristic entities. And, veil is not to be easily lifted. And in a group of companies, we really have to have a solar system. And that is exactly, what the, explanation is. Now, kindly come to, paragraph 109. Placetum D. The principle of alter ego disregards the corporate separateness and the intentions of the parties in view of overriding considerations of equity and good faith. In contrast, the group of companies doctrine facilitates the identification of the intention of the parties to determine the true parties to the arbitration agreement without disturbing the legal personality of the entity in question. Therefore, the principle of alter ego or piercing the corporate veil cannot be the basis of application of the group companies doctrine. Now,
What is the difference?
the difference is this,
I can't understand the difference.
Yes, may I?
In alter ego theory,
Yes.
they are also, without disturbing the legal personality of the entity in question, cannot be disturbed in any manner because it's a separate entity. But that is for the purpose to determine the true parties to arbitration.
Correct. That's what I said. This is, a case referring to an arbitration agreement.
Specific.
Yes, because the intention could be, that they are the only 2.
Otherwise, we are not lifting the corporate veil.
No,
only
correct.
For the
Correct. Now, what are the other cases you cited? Yeah. Now, there were. Give the compilation.
Just one second. I'll show you a note also on this.
Yeah. Now, kindly take 2022 2 SCC 275.
Yes.
This is, my lord, on, my lord, reliance on matters which had not been relied upon, my lord, before the learned judge. My lord, state of Chhattisgarh versus Sal Udyog, my lord.
Hmm.
Lordships have that, my lord.
Yes, Charlie.
Now, my lord, kindly come to paragraph 21, my lord.
Hmm.
21, 22, and 23. My lord, the submissions were in para 10 to 13. I believe those have been shown. My lord, my learned friend has, my lord, shown those, my lord.
Hmm.
Kindly, my lord, come to, my lord, para 21. My lord, in the memo of appeal, and my lord, my lord, instead of memo of appeal, say section 34. Kindly see, the appellant state had taken a plea on the aspect of levy of supervision charges in grounds J and K of the section 37 petition. And my lord, the two grounds, my lord, are set out.
Hmm.
It was specifically taken, my lord, in the 37. Then, my lord, para 22, though the aforesaid plea has been recorded in paras 3 and 5 of the impugned judgment, as can be seen from the following, it has remained unanswered.
Yes.
So, my lord, the issue had also been raised, my lord, in, my lord, then, my lord, 23. On a conspectus of the facts of the case, it remains undisputed that though the appellant state did raise an objection before the arbitral tribunal on the claim of the respondent company seeking deduction for which it relied on so-and-so circular to assert that recovery along with express was a part and parcel of the contract executed with the respondent company, the said objection was turned down by the learned sole arbitrator by giving a complete go-by to the terms and conditions of so-and-so. Circular was also, my lord, ignored. So, my lord, this issue, my lord, had been raised, my lord, in, my lord, both before the learned single judge and, my lord, before in the appeal. Then, my lord, kindly come to para 24.
Yes.
My lord, on this basis, my lord, it was said, para 24, we are afraid the plea of waiver taken against the appellant state on the ground that it did not raise such an objection in the ground spelt out in the 34 petition and is therefore stopped from taking the same in the appeal preferred under 37 would also not be available to the respondent company, having regard to the language used in 34(2)(a) of the Act that empowers the court to set aside an award if it finds that the same is vitiated by patent illegality appearing. Once the appellant had taken such a ground in the section 37, and it was duly noted in the impugned judgment, the High Court ought to have interfered by resorting to setting aside an award under section so-and-so could not have been invoked by the court on its own in exercise. In other words, the respondent cannot be heard to state that the grounds available for setting aside an award under so-and-so could not have been invoked by the court on its own in exercise of the jurisdiction vested in it under section 37. Then, my lord, and my lord, Hindustan Construction, my lord, was also relied on because my learned friend, my lord, says we can look at all, your lordships can look at all this because of, my lord, 34, my lord, 2B.
Yes.
The court finds that the arbitral award is in conflict with the public policy of India. Then, my lord, for the avoidance of any doubt, it is clarified. That was, of course, a case of, my lord, amendment. And, my lord, the argument was, my lord, that it was barred by limitation. And, my lord, they said, no, here the court can actually amending the grounds because the court, if it finds, can, my lord, look into this issue. My lord, here, my lord, we are on a slightly different footing. My lord, all the records, my lord, were before, my lord, the court. And the only, my lord, basis on which it was urged that, my lord, there was, my lord, an infraction, my lord, of the schedules, or, my lord, a violation of section 12 was on the basis of what was put forward. Now, my lord, what's the other case? Yes, Vinod Bhaiya. Vinod Bhaiya. No, I want mine, I guess. So, yeah, don't worry. My lord, Vinod Bhayalal Jain, my lord, I think, my lord, it's volume 3, 412, my lord, of the compilation, 2020, 15 Supreme Court cases, 726.
Yes.
My lord, here again, my lord, this is, my lord, a pre-amendment, my lord, case, my lord, where, my lord, the guiding factors, my lord, had not, my lord, the statutorily guiding, my lord, the statute itself, my lord, contemplated, my lord, what would guide, my lord, my lord, issue of, my lord, conflict, if I may use that, my lord, expression. And in that context, my lord, para 9 and 10, my lord, were para 9 and 10, which my learned friend relied on, my lord, is to be, my lord, looked at, my lord, in that context. Ei Dhruvo, okhane jodi dark hoy while I'm here, just adjourn it.
Mr. Diwan has argued, Mr. Mukherjee, that even after the amendment, justifiable doubts is there. And in that context, the explanation says that schedules will be the guide, 5 will be the guiding factor.
Correct.
7, he says, is ineligibility. If one falls under 7, absolute bar,
Correct.
ineligibility.
Yes.
But that does not mean that other bars raising justifiable doubts cannot be raised.
Yes, my lord,
So there's a gray area between
Yeah.
penumbra region.
yes,
between
my lord,
Schedule 7
my lord-
scenario and
my lord, I adopt here, my lord, I'm ad idem with my learned friend. My lord, it's exactly what HRD also says. My lord, HRD, my lord, 12.1, my lord, is the general.
right. 12.1 is the guiding light in
Correct.
HRT, read with the IB.
Correct. So, my lord, keeping in mind that, my lord, these objective criteria came in, my lord, a 12.1, my lord, disclosure, my lord, whether that same disclosure has to be repeated, my lord, will, my lord, arise considering now we have a guidance, because that was, my lord, completely subjective.
So the continuance cannot be tested on the anvil of the subjective.
Correct.
perception of the-
I'm grateful, my lord. That's how I want to put it.
All right. All right.
Because now, my lord, what happens, my lord, is, my lord, this guide, my lord, comes in, and it's statutory, my lord. This provision, my lord, is not because the agreement says something. It comes in by way of statute. And, my lord, why I say, my lord, also in this context, kindly see explanation 2, because, my lord, if, my lord, it had included everything, other, my lord, interpretations of affiliate, and, my lord, applying to, my lord, an individual, there was no need, my lord, for IBA, my lord, to amend. It wasn't clarification, my lord, 2024.
That we asked you and you pointed out that it
Yes.
was not clear.
Which is why I say, my lord, that, my lord, that explanation, my lord, is exhaustive. And, my lord, what, my lord, I disclosed, my lord, at the initial stage, which was purely subjective. Now, my lord, that I have, my lord, a guiding light, my lord, it's not to be tested solely on the basis of, my lord, the arbitral tribunals, my lord. And then, my lord, the
Disclosure-
cases, my
disclosure
lord.
was pre-amendment
Yes,
and the continuance of the liability to disclose is post.
yes,
So therefore, there's a
Yes,
distinction. between
yes. My lord, that is, my lord, according to me, my lord, the most, my lord, vital, my lord, issue. Did he cite all this Ravi Raghunathan? and all that?
Central organization, paragraph 1.
Yeah. My lord, this is also in similar lines, my lord. Central Organization for Railway.
That court judgment.
Yes, my lord. My lord, your lordship. Again, my lord, I find, my lord, it's unnecessarily lengthy, but my lord, that's my lord, 2025 4 Supreme Court cases 641.
Two things.
Four. You cited it today only. 2025 4 Supreme Court cases 641, volume 2, my lord.
Yes.
My lord, it's 733 of the report, 284 of, my lord, the.
Yes.
In fact, my lord, HRD, your lordships will recall the language. My lord, third party
Yes.
when made aware of the circumstances of the case, whether could have, my lord, any, my lord, apprehension. It's the third part. And the same thing here, my lord. So, my lord, 12(1)(a), my lord, in the context of, my lord, Schedule 5 and Schedule 7 and, my lord, 12(2).
The third person and common man test, Mr. Mukherjee, is a myth.
It is.
It's a myth. There is no common man. There is no, third party. Third party there are common. There is no common man. While it's a completely unrelated thing. While we were choosing gym equipment for our Vision Bhavan, our judges' residence, so the standards are general standards of a common man, which does not suit anybody, any one of the judges who are there. So, because the mobility is dependent on your own mobility, your structure, body structure. There is no common man who fits the common man definition. So that made me think that is also applicable to law. I mean, who is a common man? A common man for say a trademark case. The test of a common man will be different from an arbitration case. Anyway, we go by the
But it
common
all-
man
it
whenever we
all
don't have any
started,
answer.
My lord, it's all started with, my lord, the man on the Clapham omnibus. My lord, Clapham didn't have the gentrified people, my lord. So, my lord, persons who boarded the omnibus in Clapham, my lord, in a very class-conscious society
Very,
like
very,
Britain,
very. And that was a
then,
that was a sort of description of plebeian people.
yes,
So which is completely different from the Indian context of R.K. Lakshman.
true, my lord, absolutely.
Is just the opposite actually. So do we conclude here or we'll come back and there is something Mr. Datta has to add something. So we'll come back.
Well, yes, sir. 5-10 minutes.
No, whatever. Yes. Yes.
My lord, may I come to, my lord, the last case cited today, my lord, Sundaram Pillai's case, my lord. It was a loose copy, which was, and take out the Bombay decision. Take it out. Then one of the physical ones. My lord, kindly come straight away to para 45, my lord, which is, my lord, internal page 22, my lord, of the report. You've given the print, no? Internal page 22.
Yes, yes.
My lord, kindly have a look at, my lord, para 45. So far as the act in question is concerned, the matter does not rest only on the question of default, but by an amendment, an explanation in the following terms was added to the proviso to section 10(2) of the Act. Explanation: for the purpose of this subsection, default to pay or tender rent shall be construed as willful if the default by the tenant in the payment or tender of rent continues after the issue of 2 months' notice by the landlord claiming the rent. Now, my lord, on the words of, my lord, the explanation itself, my lord, it is amply, my lord, it's clear, my lord, is that it only incorporates, my lord, one instance of a willful default. It doesn't exhaust everything because it says, my lord, shall be construed as willful. This situation. It's not that other, my lord, situations, my lord, cannot be considered to be willful because the act, my lord, remained, my lord, the principal provisions, my lord, remained, my lord, to the act. Now, my lord, kindly see, my lord, this is exactly what the Supreme Court has held. Para 63, the majority view, my lord. Para 63, my lord, print page 28. The argument of the Council for Landlords was that even if a notice under the explanation is given, that does not take away the jurisdiction of the proviso to determine whether or not the default has been willful if it contains the qualities and attributes referred to above. Because what the explanation does is merely to incorporate an instance of a willful default and is not conclusive on the point and would have to be construed by the court in conjunction with the conditions mentioned in the proviso. We are, however, unable to go to this extreme extent because that will actually thwart the object of the explanation. As we read the explanation, it does not at all take away the mandatory duty cast on the controller in the proviso to decide if a default is willful or not. So, my lord, this is in the domain of the controller. Act, my lord, is clarifying that the situation in the explanation would be construed, my lord, as a willful default.
But your explanation also says it encompasses,
Encompasses, my lord, not, my lord,
not exhaustive. That is what it is.
that's, my lord, their argument. My lord, I say, my lord, that it is exhaustive because if it weren't, there was no need, my lord, to have, my lord, the amendment and revision, my lord, which was, my lord, made. Because it's come, my lord, from the IBA. And, my lord, I say in that context, one has to see party, the expression party, my lord, in the surrounding circumstances. Now, my lord, the Bombay decision which was relied on, my lord, Ravi Raghunath. Where is that? Where is it in the compilation? No, compilation. My lord, I believe it was given separately, my lord.
Yes. Okay. No.
No. My lord, paragraph 28 and 29, your lordships have that, my lord?
20 and 20, yes.
My lord, kindly see, it is seen that objection numbers, my lord, para 27 actually, my lord, has, my lord, the objections. However, during the course of his oral submissions, Mr. Jain has sought to attack the arbitral award by raising following 6 objections. Failure to record independent reasons by the learned arbitrator on various issues, transactions being ab initio void on account of provisions of 36A, non-securing of prior permission to transactions under 43, consideration of insufficiently stamped and unregistered document which was not admissible in evidence, non-recording of any finding about readiness and willingness to perform while granting relief or specific grant of release which are impermissible. It is seen that objection 1 and 4 to 6 raised during the course of oral submissions are not pleaded at all in the petition. Objection number 3 relating to requirement of prior permission under so-and-so has been pleaded in the petition. The objection number 2 relating to requirement of securing permission under is again not clearly pleaded, and ground clause K vaguely states that the petitioner submits that by not appreciating legal permission required by so-and-so. Faced with the difficulty where most of the objections orally canvassed by him are not raised in the petition, Mr. Jain has submitted that under the public policy doctrine, it is the duty of the court to examine correctness of the award. And even if any particular ground is found to be not pleaded, but the award is found to be bad, it is the duty of the court to set aside the same rather than upholding a bad award due to technicality or failure to plead any particular ground. In ordinary circumstances, it is necessary for a party to plead the grounds of challenge. The remedy of challenging an award is a statutory remedy. It is not a common law remedy or a remedy in equity. Therefore, the remedy of challenging the award must be exercised by strictly complying with so-and-so. An award can be challenged only in the grounds enumerated in section 34, and therefore pleading the ground assumes importance. If contention of the petitioner would file a single page application under 34 without pleading any grounds and would orally argue the grounds by taking the other side. But necessity of pleading grounds is based on fundamental principle of procedural fitness, etc. Now, my lord, kindly come to para 35. My lord, Sal Udyog, my lord, is referred to. Kindly, my lord, take, my lord, Sal Udyog. Para 35. Present case, however, does not involve the issue of permissibility to amend 34 for introduction of new grounds, as no amendment application is filed. However, what is urged is that a ground not specifically pleaded can still be considered by the court in exercise of suo motu power. From the language of clause B of subsection 2 of subsection 2A, it does appear that on the grounds of non-arbitrability of dispute, award being in conflict with public policy or patent illegality, the court can, in appropriate cases, invalidate an award even though the said 3 grounds are not specifically pleaded in the petition. Then, my lord, Chhattisgarh is relied upon. Then 36. Keeping in mind the above principles, where in an appropriate case, courts can be urged to trace out the vice of non-arbitrability of dispute, conflict with public policy, or patent illegality in the award, even in the absence of a specifically pleaded grounds, I proceed to decide all the 6 grounds urged by Mr. Jain. Now, my lord, this is really, my lord, following, my lord, Sal, my lord, in appropriate cases, my lord, that can be done. Now, my lord, here, my lord, in our case, my lord, it is something more than just saying you look at the award and one can say that there is a violation of, my lord, the public policy. It is on the basis of certain facts that we say that 12(1) and, my lord, the schedules, my lord, were, my lord, violated. I am not for a moment saying, my lord, that the court cannot otherwise find. But it has to be, my lord, made out on the facts. which has not been done here, my lord.
But arguments were advanced and even not taken by surprise. That is also
Arguments here.
mentioned in, before the section 34 court.
34, my lord, these aspects were not there. Certain provisions, my lord, were relied on, my lord, and the learned judge, my lord, the pleading, my lord, does not refer to all this. This comes from 77 volumes. That's the entire compilation. What's being shown to your lordships, my lord, is from the entire. To the extent it was in the pleadings and it was taken, my lord, I don't stand in the way.
That point was urged, and that was the only ground on which, I mean,
No, my lord, my lord, whatever was urged.
they urged other grounds also. While challenging the award,
Yes.
section 30, in the section 34, apart from the violation of bias and violation of these 5th and 7th schedules, there were other grounds also on merits.
No, on merits, my lord, only if I succeed here, my lord, will the matter go on merits, my lord, on the other issues.
No, that is what we are asking you. I
Yes.
mean, they challenged on other grounds also.
Yes, but
So suppose even if you win here, it has
yes.
to go down to
Yes. My lord, I'm not for a moment suggesting that.
But on this also, on this aspect of bias also, they advanced arguments and you replied to them. Arguments were advanced by both parties. So even if there was no we are asking.
No, that wasn't there. What was argued, my lord, is what the learned judge has recorded.
Yes. So therefore, there was argument made by them on bias.
Yes.
And you also addressed that point.
Yes, my lord, on the basis of certain facts and pleadings.
Yes.
Now, my lord, what is being introduced, my lord, is what was not relied on for the purpose of bias.
The entire documents were not relied on.
Yes, my lord, let us say, my lord, why there is violation of, my lord, Schedule 5, my lord, Item 2. My lord, I want to just show the three, my lord, paragraphs of, my lord, the impugned order, my lord.
And we understand your argument, Mr. Mukherjee, that there was no infrastructure of pleadings to substantiate on exactly what grounds, pinpointed grounds, these grounds were the item entries of the schedules were invoked, should be invoked.
No, there was.
In the pleadings there were.
Yes, my lord, and it was argued also only to that extent. That's what I'm showing your lordship.
Oh.
My lord, now, my lord, additional, my lord, grounds are being taken from, my lord, the records of the arbitral proceedings to say, look, this also falls foul of.
There are two aspects of it. One is that the schedule entries, there might have been pleadings on the schedule entries being violated. We are saying that whether the factual background, the underlying foundational facts on why those grounds were violated, referring to documents and all, those were not there in the pleadings.
Correct.
That is what
yes, my lord, some were there, which were placed.
Achha.
Which were placed, my lord, which I just show your lordship, my lord, the learned judge has relied on those.
Very well.
Now there are additional, my lord, material which are being relied on. My lord, I'm not saying, my lord, that this ground was not taken. My lord, kindly have a look at para 48. My lord, this is the first question. Findings of this volume 12, my lord. I'm sorry, my lord. Volumes 12 and 13, if your lordships kindly keep.
1587.
My lord, 1587, my lord.
Yes.
This is the, my lord, findings start.
Yes.
Is SSMIL an affiliate of the Bhaiya group? My lord, having heard counsel for the parties, this court finds that the Bagri group has not seriously disputed the shareholding of Bulaki Das Bhaiya and his family members in BG Chemicals Private Limited, which has a controlling interest in SSMI. My lord, Bagri is a mistake. It should be, my lord, Bhaiya.
Yes.
Not group, my lord. It should be Bhaiya, but my lord, learned judge could have, my lord, also said, my lord, Bhaiya group, which has a controlling interest in SSMI, except to say that members of Bagri family are also shareholders in SSIML. Control of Bulaki Das Bhaiya in SSIML through BG Chemicals could not be seriously disputed. So, my lord, this was the argument that, my lord, BG Chemicals has 25 point whatever, approximately 26%. Therefore, it's in control of SSMIL. and therefore in control of Bhaiya. This was the argument. On the contrary, at page 9 of the affidavit, there is an indirect assertion to that effect. So these portions I have no problems, my lord, that the learned judge considered. But there was more, my lord, which was, my lord, considered. Then, my lord, kindly come to, my lord, page 1592, which is volume 13, para 54.
So was this fixed as a preliminary point before
Yes, yes,
Oh, acha, this bias.
yes, yes. My lord, I'll tell your lordship what
Because we
happened.
don't find any submissions or anything being
Correct. On anything else,
Start-
my lord, there's nothing.
apart from this.
My lord, what happened was 36 was filed.
Yes.
Allegation was fraud and corruption, therefore no security.
36, the premise was only there.
Yes, fraud and
34 was wider.
34 was
That
wider.
common point was taken up for
And yes, and my lord, which is why your lordship found fraud, corruption given up. Otherwise, my lord, security would have, and actual bias also given up. It's, my lord, that's the submission recorded, but I have said that should not stand in the way. My learned friend should also know that. I have not said that that knocks out, my lord, his case. Because, my lord, if he can establish a violation
Yes.
of, my lord, the disclosure requirement, then the award will go.
Right.
My lord, youngsters, my lord, jump, my lord. I'm my lord, not. I am saying this, my lord. Then Mr. Diwan wasn't there that day when I made this submission, my lord. I'm not saying. So, my lord, on the preliminary issue, then there's an order
Yes.
that, my lord, both will be heard, and my lord, this is a preliminary issue in the 34. And then they give up fraud and corruption because otherwise, my lord, the security would have to be given. But, my lord, my lord, this issue did. Then, my lord, kindly see here, para 54. Given that the definition of affiliate under 12 encompasses all the companies, including the parent company, this court is hesitant to hold that SSMIL is an affiliate of CNE of the Bhaiya group in the arbitration. Then, my lord goes on to say, Mr. Ghosh's argument that an individual so-and-so and management does not qualify as an affiliate cannot be accepted.
You
And-
said that these are contrary.
Absolutely. And not just that. Now, my lord, individual affiliate. This is, my lord, lordship remembers the first question. First question, whether in control or not, my lord, of, my lord, SSMIL. Through, my lord, BG Chemicals. And, my lord, finding is, yes, in control. And therefore, my lord, then, my lord, the said Bulaki and his family members directly and or indirectly control and manage SSMIL and CNE, and the latter two companies function as per wishes and dictates of Bulaki Das. This court is therefore of the view that an individual or group of persons, including a family in control and management of a company, upon lifting of its veil, can definitely qualify. And, my lord, that is not what is contemplated. Lifting of veil, my lord, to determine, my lord, an affiliate, my lord, is not, my lord, something which is contemplated. You are an affiliate because of, my lord, a particular relationship on the face of it. Then, my lord, 104 at 1616 of volume 13. This court is unable to apply the dicta of the Supreme Court in HRD and Sheetal Maruti to the facts of the instant case, particularly the chain of events and the arbitrator representing the affiliate. Who is the affiliate? SSMIL of Bulaki Das Bhaiya, the principal party of one side in the other. So an individual's affiliate. That is, my lord, the finding.
Screen.
Report is very much necessary for the purpose of
That
The
was
date of the-
only to the extent whether any central government or state government gives any funds to the
Your Lordship
temple.
kindly come to page 87, the order passed by
87 of which?
division. My lord,
A1.
stay application, my lord, can GS3. Page 88. Start from page 88. Page 89 was the rejection. Learned Council for the states as also Union of India are directed to file their reports in the form of an affidavit within 3 weeks. It will also be open to the Learned Council for other respondents to file their affidavit in opposition, if they so desire. Within a week thereafter, affidavit in reply or acceptance, if any, be filed within a week. My lord, in spite of this direction, my lord, no report has been filed till date. But this report is very much vital, whether my lord state has granted, my lord granted, my lord.
Yes, Mr. Banerjee, file that you are for the state.
No, I'm not for the state.
Oh, no, sorry. It's regularly changing.
In the PIL,
Appearing for the state. You are appearing for the state.
MD.
You are not interested in game.
Well, I am.
Learned government leader appeared, my lord, in that matter, learned government leader appeared.
We are concerned.
Additional Solicitor General appeared on behalf of-
That is
You are for whom?
the Dakkina estate.
You are the estate. Apart from you, everybody is required to file report.
But I have.
State and union. Who is for the union? Neither
Well,
the state nor the union is interested.
I have served, my lord. My
Give a
lord,
notice to them, state
Yes,
and
I shall
union.
serve
We'll keep
notice.
it on
Yes, I shall
next
serve-
Wednesday.
Yes, I shall serve notice upon the my lord, government leader and additional Solicitor General my lord, appeared on that day in this matter.
Additional Solicitor General is having a serious issue regarding his office being served.
He appeared, my lord.
Yes, taken that formally, he has circulated a letter saying that it has to be served elsewhere. I forgot where.
My lord, before that, your lordship kindly, my lord, restored the other two, my lord, applications.
Kindly don't restore it, let it be taken up for hearing. That was my first.
no,
submission.
Those are actually suicide default.
Yes, all the matters. My lord, REIT applications are also, my lord, dismissed for default.
না,
Let that
একসঙ্গে
be restored.
send করে দেবে। We can-
Let
we
that,
can
my
oppose
lord,
that.
applications be restored. Otherwise, it could not be.
What are the GAs?
My lord, that is, my lord,
That are in appellate side.
appellate side. My lord, WP.
সেগুলো appear করছে? দাও।
Yes,
But I request the honorable bench, my lord, kindly restore it on that date, when the matter was taken up for
হ্যাঁ,
hearing.
ঠিকই আছে।
no, unless it is restored, your lordship, then there is, would not be even a reaction for affidavit. Or
No, it
notice.
has been assigned to us. We cannot
Yes.
Only
escape from the matter.
No, only problem is.
My lord, why my walk away?
My
Why
lord,
my lord?
Devattar estate or Kali temple, it has been shown. With adverse
Let
impact.
us allow the restoration, please.
My lord, we will concede. Well, can you take up the hearing on that day, restore it?
We have restored one. Basu, what's the fun in not restoring the others?
So, can you take up this matter, when the appeal has been restored, can you take up this appeal?
No. The public interest litigations are related to these.
Yes.
All have to be taken up to
We
us.
have only problem is, my lord, the matter is being delayed. And showing it.
Even if we restore, either we restore or not, we cannot. I mean, it is not. The
May I
matter has been
suggest,
assigned to us.
Kindly, well, take up this matter next Wednesday.
That's
all.
our prayer, nothing
Yes,
else.
yes.
That's nothing
We're
else.
allowing the restoration and doing that.
Yes.
Can two, what about the other can? What is the other can?
One can two, and my lord, another is also can, my lord, WPA number 480 of 2020.
That is can two.
Can two.
Yes.
And WPA P 559 of 2022 also can two. This is my affidavit service.
একটা অর্ডার রেকর্ড করে এটা হচ্ছে ওই আমরা বলে দিচ্ছি অর্ডারের মধ্যে কস্ট টাইটলে পুরোটাই আসবে যেন আমাদের লিস্টে আছে affidavits of service filed to be kept on record full stop can 2 of 2025 in WPA within bracket P number 480 of 2022 as well as can 2 of 2025 in WPA within bracket P number 559 of 2022 are the respective applications for restoration of the said public interest litigations. Full stop. The applications are contested by learned counsel for the respondents. Full stop. However, comma, upon a perusal of the grounds shown therein, comma, we are satisfied that sufficient reason for the absence of the petitioners on the relevant date has been made out. Full stop. Accordingly, can 2 of 2025 in WPA within bracket P number 480 of 2022 as well as Can 2 of 2025 in WPA within bracket P number 559 of 2022 are allowed, thereby recalling the order dated November 12, 2025, dismissing both the said public interest litigations and restoring the said public interest litigations to their original file and number, along with connected applications, if any pending on the said date. Full stop. The present two public interest litigations shall be listed for hearing along with uh, what is the APOT 138 of 2025 on December 17, 2025. Full stop. The learned advocate for the appellant in APOT 138 of 2025 shall serve notices to the Union of India as well as the state indicating the returnable date. Full stop. It is expected that the state and the union shall file the reports as per previous directions on the returnable date. It's better if you take a server copy of this order and serve. And please ask the office of the Additional Solicitor General if he will accept or somebody else. And
The direction should be in Plea for filing report. That is not in the APO.
yes, we have directed all the matters to appear together. And
Direction APOT 135 is possibly out of the original side matter, not in the PI.
no, we have directed all the matters to appear together and to give them a notice. It is expected that the reports as directed earlier will be filed. We have kept it vague generally. If you want to file, you can also file a report. We'll also ask the petitioner to file a report if they want. We are in a mood of directing reports to be filed.
Better.
I'm deeply obliged.
Why Mr. Basu was so interested in
connected
having the
application.
restoration on next days, his past history, this matter somehow runs away from the list. That is-
No. Assigned the
One-
because Justice
Exactly.
Bhattacharya.
I am
It has been assigned now.
No,
Now
so it
neither
matters-
the matters can run away from us, nor can we run away from them.
ঠিক আছে এবারে fast Grateful.
যে হিটিং আছে সেই
Written disposition.
তো নিউ অ্যাপ্লিকেশন আছে
I will be hearing the main matter.
এটা তো অ্যাসাইন তো
Yes.
তাহলে স্পেশাল অ্যাসাইন্ডে তুলে দাও। এবার স্পেশাল অ্যাসাইন্ড ম্যাটার্সের লিস্টে চলে যাও।
Any written disposition.
How can it? It is an application, that's why it's appearing at the top. Special assigned matters there.
Nothing. Nowadays, my lord, between two women and matter is being hard.
No, that may be, but
Nowadays, previously it was not there. We could have assessed one two women and yes, it will be taken up.
we are actually very eager to the hearing of this application. Let me
Any
put it
head
very clearly.
suits my lord. kindly-
Whatever head suits your lordship, as long as your lordship takes up.
no, it will appear under specially assigned matters. These are all special matters. But then it goes to the
Possibly we are scared then it
Bunch.
becomes item number 275.
May.
That's the
That
There
is
are other
what
matters,
is-
Mr. Banerjee.
one day cannot.
It
my
has been assigned to the bench presided over by me.
Right.
So as long as I am there, it will be taken up. Has to be
my lord
taken up.
cannot spare one hour for this matter any day. Or on
No,
Even if it is
we have to
January,
spare 1 hour for all the matters, Mr. Basu. You cannot take precedence.
wait for it. That is up to my lord.
No precedence. Next. দক্ষিণেশ্বর 1 ঘন্টা হবে 1 বছর লাগে অন্য বলিস নাই yes
This matter was heard by your lordships once, and the entire matter is summarized in your lordship's last order.
File the affidavit in opposition, my lord. I really, the stay petition,
The reply affidavit is also there.
what is that date of that order, Mr. Shah?
24th September 2025.
But it has to be heard.
Yes, of course it is.
Maintainability matter was, it was held in
Yes.
favor of them.
It has to be heard. It has to be heard.
Merits were not touched, but not
Yes,
placed.
yes.
In a nutshell, Mr. Shah, you argue, and Mr. Mitra also you argue.
Yes. Now, my lord, so far as this is concerned, my lord, on the merits of the matter, may I first address your lordship?
Is a Chakoti left Andamans?
My lord, Andaman has left me, my lord. I didn't have a choice in the matter, but I'm grateful, my
We are facing difficulty in that special bench matter.
my lord. I will. My lord, I'm like transported from the pandal to the temple now, thanks to God.
So let us hear the arguments from the temple.
I said, that is, my lord, too high a burden on me. My lord, may I, my lord, first take your lordship, my lord, to an agreement for mediation that was entered into between the parties. That your lordships will find at page 111.
Yes.
My lord, this, my lord, is an agreement your lordship will find is essentially between two groups. My lord, the first group being, my lord, the group made up of, my lord, the parties numbers 1 to 5. They identify themselves as the EPI group. And, my lord, the other group, my lord, which is of, my lord, the parties thereafter, my lord, they have identified themselves as the ASA group. So, my lord, there are two groups, several parties, my lord, including, my lord, one of the groups, my lord, which is the respondent number 8 company. Well, I shall come to that. Now, well, if your lordship sees, my lord, here, at, my lord, page 113, the recital to this, my lord, agreement.
Yes.
Whereas the EPI group and the ASA group had entered into certain transactions on the basis of certain terms, conditions, and considerations, agreed by and between them and recorded inter alia in the minutes of a meeting held on 15th November 2015 between Alok Saraf, my lord, who was representing, my lord, the EPI group, and Bijay Agarwal, my lord, who was representing the ASA group. The disputes and differences arose between the EPI group and the ASA group relating to the transactions forming the subject matter of the said two documents. Such disputes were sought to be resolved through arbitration. However, the decisions of Sanjay Kumar Seksaria, who acted as arbitrator, and recorded and contained in a document dated 16th March 2021, termed as a reward by Sanjay Seksaria, were not acceptable to the parties, and the parties mutually decided and agreed to treat the same as null and void and of no effect, inoperative, and not binding on the parties. And well, they said that they will not seek to enforce it. Then, 114. The parties thereafter mutually took steps to resolve the disputes and differences between them and were able to mutually agree upon and resolve some of the issues. However, certain disputes differences relating to the said two documents and the transactions and steps taken by the parties still remained unresolved. Whereas the parties, now being desirous of reaching an amicable settlement of their disputes and differences, have agreed to refer the same to mediation of Mr. Rajiv Ginodia, advocate, who is known to such and such for long years, to assist the parties in resolving and settling their remaining disputes, etc. Now, my lord, Rajiv Ginodia is therefore appointed as mediator. And, my lord, now your lordship will find, my lord, that they, my lord, set forth the terms of, my lord, the reference of the disputes to mediation. My lord, please have a look at clause 12.
Yes.
The parties are aware, at page 117, the parties are aware that amicable resolution and the settlement of the disputes and differences would involve payments of money, transfer of shares, transfer of certain lands and or possession thereof, and or of constructed spaces, transfer of existing contracts, execution of deeds, agreements, etc. My lord, kindly mark the word transfer of existing contracts, which is relevant for the present purpose. And the parties agree and undertake to do the same, take into consideration the proposal, advice, and viewpoints of the mediator, and to sign the mediated settlement agreement that may be drawn up by the mediator on the basis of the settlement that may be arrived at between the parties. And 13 is very important. The parties, I'm sorry. I'm sorry, I just suddenly lost it.
No. Take your time.
Yes. And 13, the parties declare and confirm, confirm and undertake that upon reaching an amicable settlement with the assistance of the mediator, they shall sign the mediated settlement agreement as may be drawn up by the mediator, and shall take all steps and sign all papers and documents as may be required for full implementation of the mediated settlement agreement without any reservation and or objection and or delay. Well, this is the mediation agreement to mediate. Now, thereafter, the mediation took place, and a memorandum of settlement was entered into with the parties following this mediation. Well, that your lordships will find at
120.
page 120.
Yes.
Well, this the parties are the same, so I'll not trouble your lordships with that. Now, my lord, this set forth various terms of the mediation. My lord, here your lordship will find at clause D at page 122. Or clause C and D. Pursuant thereto, my lord, that is the pursuant to the mediation agreement, several documents, including signed documents and shares, referred to as escrow documents, were deposited by the parties with mediator. Further, EPI also deposited a sum of rupees 20 crores with the mediator in escrow, which has been kept by the mediator in a separate bank account. So, my lord, documents and monies were deposited with the mediator.
You are EPI or
I'm sorry, I'm ASA, my lord.
Yes.
EPI is Mr. Mitro's client. The escrow documents include 7,90,982 shares in demat form of Hindustan Storage and Distribution Company Limited. Well, Hindustan Storage was one of the parties to that document. Well, it was this company that was really being transferred, because I was transferring, ASA Group was transferring its shares in the company to the EPI Group, against consideration. And there was a understanding that some of the lands belonging to this Hindustan company would come back to me. Some of the lands would be returned, right? Some of the businesses would be transferred back to me. Well, I shall show the lordship. Well, the escrow documents include such and such shares of Hindustan as per details mentioned below, which have been disposed. Now, these are the shares which have been thereafter listed. Well, I'll not trouble you lordship with that. Now, my lord, thereafter, my lord, it records that paragraph G.
Yes.
With the active involvement and assistance of the mediator, the parties have mutually, amicably, fully, conclusively, and finally resolved and arrived at a full and final settlement of all their disputes, differences, and claims to their full satisfaction, and such final agreement is being recorded by the parties voluntarily in this settlement agreement. The parties consider this settlement to be fair, reasonable, and in the best of their respective interests. Now, my lord, thereafter, my lord, these clauses are recorded. My lord, as to what are the terms of the settlement, my lord, I will not trouble your lordship with most of it. But my lord, may I request your lordship to straight away have a look at clause 20.
Yes.
It has been mutually agreed that the business of total and super spirit. Now, this is the business of storing, my lord, liquid, my lord, cargo. My lord, in big tankers. That has
Liquid?
been cargo.
Cargo.
My lord, fuels, oils, and other things. It has been mutually agreed that the business of total and super spirit that has been carried on till now in the name of Hindustan shall belong to the ASA Group with immediate effect. And the parties shall immediately inform this to Total and Super Spirit and take all necessary steps and sign all papers and documents for transfer of such business to the entity of the ASA Group to be specified by the ASA Group. Till such transfer is formalized, the business with Total and Super Spirit shall be continued without stoppage in the name of Hindustan, though the revenues shall belong to the ASA Group and shall be paid by the EPI Group to the ASA Group after retaining a mutually agreed amount for the use of the tanks for such period. The ASA Group may either build new tanks on the ASA Group land or purchase tanks of Hindustan from EPI Group at a mutually agreed amount and shift them to the ASA Group land. The parties shall consider the possibility of the tanks presently being used for the business of Total and Super Spirit remaining where they are at present, an allotment of the land on which the same are located to the ASA Group along with the said tanks. In such event, the area of the land so allotted shall be adjusted against the land area to be allotted in lieu of the RGSF land mentioned in clause 27, and the mutually agreed price of the tanks and infrastructure shall be paid to the EPI Group by the ASA Group. The decisions regarding the matters mentioned in this clause shall be taken within 30 days from the date hereof. Well, this was the agreement. So the agreement was that the business of Total and Super Spirit comes to the ASA Group. ASA Group will have the right to construct tanks for the business in their own lands, or they may also take over the tanks which are currently in operation and adjust the lands which are to come to them with the lands on which these tanks are constructed. And in the interregnum, what is very important is the business has to be continued without stoppage. That is a very important clause.
Yes.
Now, what happens is, this, if your lordship now sees, towards the end of this document, which your lordship will find, at page Well, it wants, may I show your lordship clause 27 also, because this reflects on the, same proposition.
Yes.
Well, clause 27 is at page 137.
Hmm.
Out of the ASA group land of 14.3724 acres, some lands allotted and belonging to RGSF, which were in the front roadside portion, have been used for the construction of new tanks by the EPI group. Accordingly, it has been mutually agreed that A, in lieu of the same, 125% of such used land area shall belong to RGSF out of the lands allotted to the EPI group, taking into consideration the premium location of the land of RGSF that has been used and to compensate for the same. And B, the land of RGSF utilized by EPI group shall form part of the 66 acres of land belonging to the EPI group. The location of such 125% land area shall be decided in a fair and reasonable manner by the parties mutually within 15 days of this settlement, with the assistance of the mediator, and the parties agree to accept the suggestion of the mediator regarding the same. Accordingly, the land area of ASA group stands increased from 14.3724 acres in view of replacement of the land used for the new tanks by 125% land area at another location. References to the ASA group land in this agreement shall accordingly mean such increased land area. Accordingly, the 50 acres of land of Hindustan and the 16 acres of land of Petro Farms belonging to the EPI group shall stand modified by addition of the portion of the land of ASA group used for the new tanks and reduction of the portion of the land of the EPI group allotted in lieu of the same. This is only to give your lordship an idea of how the arrangement of transfer of lands to accommodate the tanks was to be carried on. Then, if your lordship will kindly have a look at the end of the agreement, your lordship will find that this was ultimately accepted as a settlement. Well, if your lordship sees, one or two of the clauses, for example, 47 at page 142. The parties agree and undertake to fully implement this mediated settlement agreement in letter and in spirit, and to sign, execute, and if necessary, register all deeds, documents, agreements, papers, writings, etc., that may be required for such purpose from time to time. It has been agreed between the parties that they shall abide by the viewpoint and suggestion of the mediator in respect of the steps to be taken and the documents to be executed. 47, page 142. All rights, benefits, and advantages and entitlements granted to any party under this mediated settlement agreement shall be heritable, transferable. Then 49, the purpose of the mediated settlement agreement is to bring an amicable settlement to the claims and disputes that have arisen between the parties. Parties have agreed not to institute any legal proceeding or complaint of any kind whatsoever against each other or pertaining to the subject matter claims. Then, I shall come back to clause 50. Please have a look at clause 51 once. Or 52, I'm sorry. This mediated settlement agreement is final and binding upon the parties and fully and finally settles all claims, demands, entitlements, and disputes between the parties, including those contained in the agreement of 2018 and the minutes of meeting held on 15th November 2015, as also all other matters not covered thereby. The parties have mutual interest in this mediated settlement agreement and have entered into the same after taking legal advice as deemed fit. Parties consider this settlement to be fair, reasonable, and in the best interest of their respective interests. Parties confirm and declare that none of the parties are acting under any misrepresentation, coercion, threat, undue influence, pressure, duress, etc., of any kind whatsoever, and have entered into this mediation settlement agreement of their own free will and volition. And then, parties undertake to sign and execute all documents, papers, etc., as may be necessary to give complete and proper effect to the settlement recorded herein. Now, this settlement agreement, which is signed by the parties, as your lordship will find, at page 145, this becomes, assumes the character of an award normally. That is under section 74 of the Arbitration Act. This assumes the character of an award and therefore becomes enforceable as an award. Now, so far as this is concerned, however, the difficulties arose because immediately thereafter, there was a challenge brought to this mediated settlement, which your lordship will find at page 149. This was a letter that was addressed to the mediator. The memorandum of settlement agreement is 10th September. Now, so far as this document is concerned, this is on the 24th of September. Page 149.
Yes.
A letter is written by one of the parties who was spearheading the EPI group to the mediator, This is reference to the incident dated 10th September 2024 when my office received a call from your brother, Mr. Sanjay Ginodia, requesting us to visit your office at 6 Church Lane to sign a few documents. Based on such information, we visited your office on 10th September 2024 around 2:30 p.m. when Mr. Sanjay Ginodia handed over a bunch of papers for signing, which we signed in good faith on the assurance that the same would be handed over to us at the earliest possible date after being countersigned. Please note that till date I haven't had the occasion to go through the papers, as I have not received any copy of the said documents from you as promised. Then, my lord, the next document. My lord, this is a reply by Mr. Ginodia, my lord, denying these allegations. I'll not trouble your lordship with that document. Then, my lord, please see page 152. This is a second letter, my lord, written to Mr. Ginodia. Please refer to your above letter dated 24th September 2024 sent through email along with copy of document described as memorandum of settlement. So they admit having received this document. At the outset, I say that I'm utterly shocked and surprised after having read your said letter and the attachment thereto. On the day when the said document was presented for signing, the same was executed in good faith and reposing sheer trust without verifying the contents and purport of the said document. As you are well aware that from the date when the agreement for mediation was first entered into, considerable time has lapsed, and since the issues for mediation involved parties and complex transactions, the parties initially looked forward for informal mode of dispute resolution so as to expedite the entire process and agreed that the mediation shall be conducted in an informal manner on the basis of oral statements and documents, etc., that may be provided by the parties without there being any requirement of filing formal pleadings, and without holding formal hearings. It would appear that the original timeline agreed for arriving at a settlement was within a maximum period of 180 days. However, as the proceedings continued to be in an informal manner for a long time, the parties to the mediation were ad idem that a formal agreement is required to be drawn by the mediator, wherein the entire dispute between the parties and the respective stands of the parties could be gathered in a summarized manner for speedy and effective dispute resolution. It is based on such representation and understanding that the said document was signed and executed on 10th September 2024. It is pertinent to mention herein that there was no reason for any suspicion or apprehension while signing the said document on 10th September 24. Moreover, even after signing of the said purported document, there was no reason for any suspicion or apprehension in any manner whatsoever until when unreasonable delay was caused in circulating the final document post-signing and execution on 10th September. From your letter and the document annexed thereto, it appears that our suspicion and apprehension was right and justified. It is stated that the purported document, although captioned and presented as memorandum of settlement, but actually transpires to be the mediated settlement agreement, which was never intended to be signed by the parties herein for the following amongst other reasons. Well, then the Malad give their so-called reasons, but Malad effectively what they say is that Malad, we have signed the document, we have ascribed our signatures to that, but with that we did that based on the basis of trust, faith, and confidence. Now, my lord, the position in law, as your lordships, my lord, no, my lord, person who is sui juris and my lord signs a document with his eyes wide open, my lord, he cannot really go back and say that I did not understand, my lord, particularly since, my lord, the person is not, my lord, incapable of understanding, or my lord is sui juris. Now, my lord, this is the position. In such circumstance, my lord, we were left with no option because, my lord, when it became apparent that they are not going to give effect to, my lord, the terms of settlement, the mediated settlement agreement, which has the characteristics of an award, we filed an execution application seeking to put the award in execution. And my lord, there, amongst other things, we naturally also wanted transfer of the business of total and super spirit. Now, my lord, so far as this is concerned, the execution application was disposed of by, my lord, this honorable court by a judgment in order of 20th May 2025, which your lordships will find at page 21. My lord, what, my lord, the court essentially held, well, if your lordship will find, my lord, from the concluding portion of this judgment, is that there is an arbitration clause in clause 50 of the, my lord, mediated settlement agreement.
Mr. Shah, we fixed a matter at 1. It was mentioned on urgency ground. We'll just call it and see whether the people are there. If they are there, then we have to take that up.
Yes.
Then we'll have to stop here, Mr. Mitra. So, matter call kore dekho. You are there. Both sides are there.
Yes.
Well, wait. I will pass an order. We will just make it part and keep it hard in part for further hearing on December 17, 2025.
Well, the interim order was, well, till the next date or till further orders.
So, interim order granted earlier is extended.
Possibly till 31st, I am told.
Actually, 30
It is still 31st. It is still 31st.
further orders.
Till 31st.
Yes.
Then it remains then. Yes, 31st. 31st January.
Oh, my lord.
Still 31st of
I'm
January.
sorry.
Yes.
ঠিক আছে 31st January আগে হিয়ারিং হয়ে যাবে তো।
My lord,
Yes. Yes, Mr. No.
আমি এবার একটু বলি।
Yes.
It be at, my lord, it's a parted matter. Can it be at the top, my lord?
My lord, will your lordship indicate a date, my lord? 15th, 16th, and 17th. I am in difficulty.
Then last day then before.
My lord, there is some pressure on our. I'm sorry, my lord, but in that event on any other day, but
Well,
I know your lordship takes up origin the
Only Wednesdays.
Yes.
I know that
আর কোনো পাঠার ম্যাটার হয়েছে আজকে? এত কোন পাঠার একটা হয়েছে? এর আগে আরেকটা হয়েছে? পাঠান না পাঠান। পাঠার এটা পাঠারটা উপরে দিয়ে দেবেন পরের বুধবার। পাঠারটা স্পেশালি অ্যাসাইনে যদি কোনো পাঠার হয় সেগুলো উপরে থাকবে। এটা পাঠার হচ্ছে এটা উপরে থাকবে। First of the specially fixed matters, especially assigned matters.
Well, it's
17th you are in difficulty. Then Mr. Mitra, what do you do? Whatever is.
If you no. The 17th, my lord, I'll be very honest, my lord. There are some other matters which have been fixed, my lord, in the morning. My lord, I will, my lord, have some difficulty. I mean, in the city, but my lord, I will.
Whatever you say, then the only Wednesday left before the vacation is the 24th, last day, 24th of December. Don't know what will happen on that.
My lord,
Mr. Mitra has instruction to oppose that.
I will be very embarrassed, my lord. That is all I can say, my lord. Either before your lordship's
embarrassing
court
for both
or
of us possibly, but
Let it be on 17th, then let somebody else start and do, we'll see if it is 17th. Opposition and reply filed today be kept on it. Reply, you have to file another copy.
2 o'clock or something like that.
2 o'clock to 9 hours. Hello, will your lordship be taking this matter up at 2 o'clock on the 17th after, my lord, the lunch recess?
No.
No.
Original set matters first.
Very,
Let us see what happens.
very well.
Colin, the matter to tackle. Yes.
I'm for the appeal.
Yes.
This is an appeal from an order in its jurisdiction, my lord.
Very short
My lord,
notice.
Very short.
Yes,
matter, my lord.
obviously.
Well, I'll just indicate.
It is a short notice.
No,
not short.
Short notice and matter is also very short.
What is the matter?
My lord, the petitioners, the petitioner in the court below, my lord, is the owner of a plot of land. Well, along with the
You are the
private,
writ petitioner.
I am the writ petitioner, my lord. Well, along with the private respondent, because our predecessor interest was the owner of that land.
Private respondent is appearing before us.
Yes, he's for the private respondent. The private respondent took a loan. Will mortgaged second property, not this property. They admittedly mortgaged the second property, but the second property is a pond. A pond and some other part of the.
How are you related to him?
He is my son, the first petitioner's son, one of the son. He took a loan. He mortgaged a separate property. On that property, he has, I don't know what declaration he has given before the bank. Well, he has said there is a house on the pond, and a 2-storied house on a pond. The nature and classification of the land is pond. There is a pond. Will have indicated. Well, what has happened? The banks, he defaults. The banks come. Well, banks.
You are his mother and brothers.
Mother and brother. The bank comes. The bank sees that that's a pond, and there is no 2-storied building. What the bank does, the bank identifies my property, the non-mortgaged property, my lord, as the property on the pond. They affix the notices. They threat me to leave. They ask me to leave the house. They try to my lord, attach the property to sale. My lord, this has been done in collusion with the private respondent. Because since the bank has given him a loan, well, I can show. If it kindly comes to Lord, the DM's order.
So what did you challenge?
My lord, I had went to the single bench, my lord, stating that the property which is sought to be mortgaged is my property, which is not the secured asset. My lord, this is wrong classification.
What is the relief sought in the writ petition?
That is the DM order.
That's the DM order, but not to execute DM order on my house, on my property. Because the photographs they have, there is no two-storied building on that land. Only my property is there, and notices have been affixed to my property, and I have been asked to vacate.
But these challenges are to be preferred before the tribunal, not before the.
Well, I am not the secured creditor.
So let's accept
Anybody affected.
Well, the
Yes.
difficulty is,
Anybody affected.
Milord, we did not know about this order. Milord, kindly have a look at the order, Milord, page 85. There is a,
So who is colluding with whom?
but that's the difficulty, Milord. I'll say why. Milord,
No, you also may be.
no, I'll indicate why I am not, Milord. Milord, there is no two-storied building. I like given the documents, Milord. It's a pond. There cannot be a two-storied building on a pond. And Milord, what he has done, he has given a declaration before the bank that there is a two-storied building. The bank has granted him loan, stating that there is a two-storied building on a pond. Now they have come and seen that there is no building. Now they want to take my building now. Well, I'm having a blood cancer. My grandson, Milord, who is suffering from blood cancer. I have no.
Learned single judge has said, since the order under section 14 has been passed in respect of the property mentioned in the schedule, authorities cannot take possession of any other property other than the one which is mentioned.
So we have been restricted.
That is the difficulty.
We should
Milord,
go by the schedule of the
I will show Milord why. Milord, I was only affected by this part. Kindly comes to page 85.
Your property is not described in the schedule.
No, I'll say why. Milord, I'll just indicate Milord, why I'm apprehending. Milord, kindly understand, Milord.
That was dealt with by the Lord.
Milord, kindly sees this, Milord.
It is very clearly mentioned.
Kindly gives me a moment.
Submits that there is no two-storied building standing.
That's my submission.
Court is not inclined to go into that issue since the petitioner has no claim in respect of the property.
Yes, I do not have any claim in respect of the property which has been mortgaged. Well, I only have a claim because they want to dispossess me from this property. Milord, on ground they're doing it. Milord, kindly does this, Milord. Kindly does this.
Court has restricted them, the bank, to have recourse to 14 only in respect of the scheduled property of the mortgage.
Kindly. Milord,
does the mortgage deed describe your property?
No, Milord, no. Milord, I'll indicate why, Milord. Kindly gives me a moment. Milord, kindly gives me a moment. Milord, kindly comes to page 85 once. Yes, Milord, 1 minute. Kindly comes to page 85 once.
Yes.
Milord, page 85, Milord, schedule of the property. They say, Milord, the land and two-storied building. Milord, in the entire locality only I have a two-storied building and nobody else has that. There is no other building. Milord, the bank has affixed photograph. The bank has affixed photograph or the notice on my wall, Milord. They wanted me to leave the property. Milord, kindly the report be called from the BLR whether there is any two-storied property on that this property which has been mortgaged. Whether there is a two-storied building, well, nothing else, Milord, I want.
Single
well, let the BLR say,
schedule.
No, there is no two-storied building. I'll go out of the court.
They have submitted. They have no claim over the schedule.
Schedule also specifies the property.
But deed schedule is a pond. I don't know what deed he has supplied. At least in the property which the deed has. I'm not a party to that deed. I'm not the owner of that land.
Property is in which dag?
Well, my property is in 188 and 189.
We'll clarify that.
We'll say that the land single
kindly does one thing. Only one prayer. Well, kindly one prayer. Well, everything goes. Well, I'll be out of the court. I'll withdraw the appeal. I'll go, Milord. Well, kindly let there be a report from the. There is no such a report.
Why?
Let there be a report from the. This is a writ petition, Milord. Well, kindly appreciate.
Why, Lord?
Well, let there be a report from the BLR whether this property 190 with this scheduled property has a building or not.
That's a surface
Only this
application.
much, Milord. Well,
Challenge.
Milord, they'll dispose me from my property, Milord. Well, kindly.
The present the appeal is taken up for hearing out of turn in view of the urgency mentioned by learned counsel for the appellant. So next para, the appellant's case is that the private respondent, being the son of appellant number 1 and the brother of the rest of the appellants, took loan from the respondent bank, with showing a property, which is actually a pond, in respect of RS and LR dag numbers 196 and 195, as the scheduled assets, as the scheduled asset. Full stop, next para. However, it is pointed out that although the present appellants do not have any claim on RS and LR dag number 196 and 195.
No, 180 and sorry, I'm extremely sorry.
Not.
The property of the appellants, situated at RS dag number 188 and 189, comprise of a two-storied building. It is further submitted that erroneously, the mortgage property on RS and LR dag numbers 196 and 195 has been described to be a two-storied building with RCC roofing. Full stop. Next para, it is contended by the appellants that since the two-storied building standing on the property of the appellants on dag numbers 188 and 189 is the only such building in the locality, comma, the appellants reasonably apprehend that in the garb of taking possession of the mortgage property of the private respondent, comma, the respondent bank shall take possession of the property of the appellants. Full stop. Next para, as such, comma, being aggrieved by an order passed under section 14 of the Surfacy Act by the concerned magistrate, comma, the writ petition was preferred, comma, which culminated in the impugned order, whereby no specific protection has been given to the appellants. Full stop. Learned counsel for the appellants further submits that a report be called for from an appropriate authority to ascertain the identity of the mortgage property and as to whether it is comprised of a two-storied building. Full stop. Next para, such contention is opposed by learned counsel for the respondent bank as well as the private respondent, and it transpires and it is submitted that the impugned order takes care of the grievance of the appellants. Full stop. Next para, we find from the impugned order that the learned single judge observed therein that after going through the schedule of property as mentioned in the impugned order, comma, the said court found that the schedule of property mentioned therein is as described therein. Full stop. It was further recorded that the petitioner claims to be the owner of RS dag number 188 and 189 and not LR dag numbers 196 and 195. Full stop. The learned single judge went on to observe that since the order under section 14 of the Surfacy Act has been passed in respect of the property mentioned in the schedule therein, comma, the authorities cannot take possession of any other property than the one which is mentioned in the order dated April 4, 2025 under the heading Schedule of Property. Full stop. Next para, it was also observed by the learned single judge that since the petitioner has no claim in respect of the property mentioned in the schedule of property in the order dated April 4, 2025, comma, the petitioner cannot have any reasons to feel aggrieved by the said order of the district magistrate. Full stop. Next para, thus, comma, we find that, comma, irrespective of the description of the scheduled property, comma, which is the secured assets of the mortgage of the private respondent with the respondent bank, mentioning a two-storied building, comma, the boundaries of the secured assets are not defined merely by the description but by the dag numbers as given in the schedule. Full stop. Next para, hence, comma, we find that since the mortgage is restricted to RS and LR dag numbers 196 and 195, comma, the ambit of the order under section 14 of the Surfacy Act would remain restricted to the said dag numbers only. Full stop. In the garb of the said garb of taking possession of the said dag numbers, comma, the property of the appellants at dag numbers 188 and 189 cannot be taken possession of by the respondent bank. Full stop. Next para, since the impugned order, comma, in letter and spirit, comma, corroborates our above findings, comma, we do not find any scope of interference with the same. Full stop. Accordingly, this OT 317 of 2025 along with GA1 of 2025 are disposed of in the light of the above observations without any orders to cost. We have made it very clear that they cannot take possession of, irrespective of the description we have seen.
Grateful, grateful. That served the purpose. That was the only purpose, nothing.
If it is
taken care of by the single bench also.
We have said that only.
Yes. Day before yesterday, the survey was made. And there was only the branch management, what I have been told, The branch manager came, it was shown to the branch manager.
They'll take
The branch manager said that there was a building. I don't know why it
they'll take
vanished.
possession of the reflection of your building in the pond. Your building will be reflected in the pond, they'll take possession of it.
Grateful, my lord. Grateful.
Yes.
My lord, only thing, my lord, these 13 matters, my lord, actually same issues. My lord, FAT, my lord, appeal and applications.
Applications can appear
Applications. All are appeal and connected applications.
under the heading application. Just write application.
Applications. And my
The
lord,
written application in that slip.
my lord, number is there.
No, write application.
Application.
The heading has to be written. Yes.
And
May
my lord, only thing, my lord, let it appear on Monday because 12th, the execution date, my lord, is fixed.
Whenever the files comes,
File has come.
they'll appear. Yes.
My lord, I will write application.
My lord, may I have your lordship's kind leave to mention an appeal for non-prosecution, my lord?
Yes.
Order 41, Rule 11.
My lord, order 41. My lord, there's some urgency in the matter. That's why I'm seeking inclusion in the list. Order of 1st December 2025. Order of injunction
It
granted
will be
against
given in
me.
the list as soon as the file comes. Yes.
Order 41, Rule 11.
Order 41 rule 11.
Yes, call on the list.
My lord, may I have my lord's leave to mention my lord's single bench matter, my lord. My lord, there is some urgency. My lord, there is a change of situation. My lord, on 18 September, my lord had passed an order directing the writ petitioners who are the consumers of DVC to deposit the arrears in 2 bunches. First by way 50% by cash. Second bunch was by BG. My lord, the last date of compliance of such order is 17 December, my lord. My lord, subsequently, there has been a substantial change in the circumstance. An order of appeal has come. My lord, the effect of that order is now the consumers will be entitled to a substantial amount of money, which will not only cover
It will appear under what heading? Application.
These matters appeared last Friday. They chose not to appear. I pointed out that they are in breach of your lordship's previous order, which required them to comply
Yes.
with that order. Lordship has extended the time for them to file 1 week to file their opposition to my vacating.
My lord, that has been
and
filed,
1
my
week
lord.
thereafter, 19th, it is appearing. Let these applications also come up on time.
Difficult, I understand.
This application will appear on 19th. It has been directed. So it will appear along with that.
My application vacating is Can 3. They have now taken out another application for modification of lordship's order.
No,
He
just
is vacating
this
application.
will appear along with the main matter on
But
19th.
may
Very
only
grateful,
request, today the outer limit is I'm mentioning this because the outer limit is 17 December. If it can appear on 1st December,
no.
because may just indicate, one second.
Not there on the last occasion.
They
But
chose
I
one of the affidavit.
it's not a question of choice. But I personally was, but there was some medical emergency.
Maybe somebody should have been there.
I should have been. But
No.
for
No,
the fault of the lawyers,
no.
but
Yes.
may just one request,
No, Mr.
just
Chakraborty, because you are not there on the last occasion, you cannot be given a premium by.
no, I'm not asking.
No, it will appear on the returnable date.
One sentence,
No sentence. Yes.
one sentence, just one sentence.
You have already been sentenced.
At the cost of being rebuked, one sentence, because the refund issue.
Pay the cost of being rebuked, but the matter.
Whatever it will be a
No, Mr.
blessing for
Chakraborty,
me.
no. Yes.
But one second.
Sorry, no.
Fresh matters, sir. Fresh matter, my lord.
What matter? Application?
FAT.
First appeal hearing or application or what?
Application.
What number? What is the number of the application?
525/2025.
দেখে নিন application heading লেখা আছে
My lord, with the leave,
heading লিখে দিতে বলুন
my lord, with the leave of the Honorable Justice Supratim Bhattacharya, may I mention one application for review along with Section 5 and stay application, my lord.
mention when I sit singly on Friday.
Yes, my lord, because the contempt arising out of this matter, contempt application is fixed on 12th, my lord. Let it appear
Nothing doing. Mention that you file it in file it and
without certified copy. I am
Acha,
bringing your lordship's
leave we
kindly-
cannot grant sitting here. I can only grant on Friday. How can I grant leave?
Since contempt application
On in division bench I cannot.
on that,
Sorry, no.
well, without certified copy, since
Cannot grant to leave sitting in division bench.
I could not.
Yes.
My lord, may I be permitted to mention one matter, my lord? I want to move an application for stay, my lord. My lord, because against
You are mentioning the stay application to be included in the list.
I have filed a memo of appeal and number has been put, FMAT number 490 along with CAN application. Stay application for what, my lord? Against the order dated.
Why are you mentioning it? For inclusion in the list?
No, my lord.
Sorry, no. Call on the list.
Item number 1.
Yes. Who is appearing?
I beg to appear on behalf of the state respondent only.
Why was it directed to appear as to be mentioned?
Lordship, pursuant to your lordship previous order, my lord, we have complied with the order, my lord, and may I humbly, my lord, submit the compliance report for
No, why did you direct? Yes, return.
Lordship directed them to pay cost.
concerned BLRO be present personally, Lordship. And
No, we dispensed with his personal appeal.
last occasion he has appeared.
Yes, we
Lordship.
dispensed with.
Lordship. But some
No, no,
compliance.
cost was to be paid and the receipt is to be filed today.
I have, my lord, annexed the
Receipt.
my lord, Lordship.
Very
He
good.
has personally, my lord, deposited the sum of rupees 50,000 and which has been
Fair enough,
is due
fair.
with the- And other part of for the compliance, my lord, already, my lord, complied by the concerned BLRO, my lord, record has already been, my lord, corrected. Only my in favor of the, my lord, petitioner as well as the private respondent, my lord. Only, my lord, 27 decimal, my lord, that has already been given as patta. For that, my lord, may I submit, my lord, the proposal, my lord, that has not been annexed, my lord, with the compliance report, my lord.
Give a copy to them also.
Lordship. My lord, the concerned BLRO asked for the, my lord, annulment, my lord, and that is
No, what was our direction we directed the BLR to comply with the previous directions of this court and correct the. There were previous directions, he did not comply. For that, he had to pay the costs. Now we directed him to correct the records of right in favor of the petitioners.
Lordship, that has been corrected, my lord, only in respect of the, my lord, 27 decimal, my lord, since it has been, my lord, it has been, my lord, given patta, my lord, and that requires, my lord, the annulment by the SDO. Thereafter, my lord, record can be, my lord, corrected by the concerned BLRO. That has been, my proposal has been given, my lord. I have, my lord, just submitted one paper, my lord. That has not been annexed with the compliance report.
Yes, what do you say, Ms. Mai?
Dear Lordship, substantially complied with, but only that part which my learned friend was submitted in people, Lordship, that has to be complied with by them.
Where will proceed persons of this? Learned counsel for the learned counsel for the state files a compliance report indicating that the order of this court directing the BLRO to pay costs from costs of rupees 50,000 personally has been complied with. Full stop. The receipt in that connection is also annexed to the compliance report. Full stop. Next para, insofar as the other part of the direction dated November 27, 2025 in WPLRT number 185 of 2025 is concerned, comma, it is submitted that although the rest of the concerned plot numbers have already been recorded, comma, pursuant to the order of this court, comma, in the name of the petitioners, comma, only regarding a portion of plot number 102, comma, since there is already an existing patta, comma, a proceeding has to be taken out for annulment of patta, which has also been initiated at the behest of the BL and LRO. Full stop. A communication in that regard from the BL and LRO to the subdivisional officer, comma, Kharagpur, comma, Paschim Medinipur, dated December 9, 2025, is also placed on record. Full stop. Next para, accordingly, comma, since the BL and LRO has complied with the order, comma, no further order need be passed. Full stop. Since the WPLRT itself has already been disposed of, comma, let the matter be reflected in the computer information system of this court as disposed of. Thank you. Thank you.
Your Lordship, I am appearing for the appellant. My learned friend has mentioned the matter, my lord, for getting the paperwork. It is my mistake, my lord. In course of this week, he will get the paperwork.
And another thing, Lordship.
You'll get the paperwork, miss?
My lord, I will supply the paperwork. My lord.
You have filed it?
Yes, yes, I have filed it. There was a direction of supply. I missed that. I pay apology for that, my lord. In course of this week, I will.
You are appearing for respondent number 1B also?
I am for the Lordship substituted respondent, Lordship.
1B is also included in that.
And Lordship, another thing, Lordship, by order dated 15th of November 2019, there was a direction upon the court below to keep the skeleton record such that the commissioner could be, Lordship, proceeded with. But the entire record has been sent down before this Honorable High Court.
If the court can proceed on the basis of the papers, whichever they have, then
they have nothing.
So far, trial
entire record trial court has sent out.
You furnish the records. We need not send down anything. Learned counsel for the appellant submits that the appellant, comma, although in default of the previous direction to serve paper books on the respondent, comma, shall serve copies of the paper book on the learned advocate for the respondent within a week from date. Full stop. Next para. Accordingly, the appellant is directed to serve copies of the paper book on the respondent within a week from date. Full stop. Next para. in view of appearance of all the substituted respondents, including respondent number 1 small b, through counsel, comma, you previously appeared for 1A and 1C, Mr. Sannal.
No, Lordship.
Comma, further service of notice of appeal on the substituted respondents is dispensed with, and the office report dated December 3, 2025, indicating that Taliban and postal costs have not been deposited, stands waived in that regard. Full stop next para, the appeal be treated to be ready as regards service. Full stop next para, learned counsel for the respondent, substituted respondents also submits that despite the observation of this court that the learned trial judge may retain the skeletal records for proceeding with the final degree proceedings, comma, the entire records have been sent. Full stop, be that as it may, comma, the trial court shall continue with the final degree proceedings, comma, if necessary, by taking copies of the appropriate documents from the parties.
Bibliography.
কারণ তুমি mentioned it. You wanted to arrange the papers?
Yes.
You want that liberty only?
So far, no. This is
We have an application for vacating.
No, today that is not appealing.
It's appearing, and my lord, the appeal is not maintainable.
maintainable. This is order 40.
No, he had asked for leave to rearrange the annexures to one of the.
We have also filed a vacating.
Maybe you have filed, Mr.
In the list.
Chatterjee, this is it is in the list has to be mentioned. Only on their part to rearrange the papers. That will appear as an application. That will appear as an application.
The appeal is not maintainable on the face
That will
of
appear
it.
as an application, Mr. Chatterjee, not like this.
But there was a caveat, they obtain an order behind our back.
We'll list the vacating application.
But it's there in the list today itself.
No, it is appearing under the heading to be mentioned, Mr. Chatterjee. No, there are several things. Everything is reflected in the list. It is not appearing under the heading application. Sorry, you're wrong.
Very well, my your lordship, but the problem is the appeal is wrong itself.
Maybe. On the mentioning of learned counsel for the appellant to rearrange the annexures to which can?
To can number 1.
To can 1 of 2025, comma, the matter has been listed today. Full stop next para. Leave is granted to the learned advocate in record for the appellant to rearrange the pagination. You won't open the papers and annex it, or
No, annexed it, but it has been reshuffled.
very well. To rearrange the papers, rearrange the annexures to can 1 of 2025 and paginate the annexures appropriately in both the judges' copies during the course of the day. Bring your clerk and do it during the course of the day. Full stop. Next parallel, senior counsel appearing for the respondent submits that the appeal itself is not maintainable and an order was obtained behind the back of the caveator stroke respondents, comma, for which the respondents have filed can 2 of 2020.
Can 2 is another set.
Can 2, my lord, is
And
one.
Can 3.
Can 2 and of 2025 and can 3 of 2025. Full stop. Let all the applications be listed for hearing tomorrow. ওরা রিঅ্যারেঞ্জ গুলো করে দেবে, পেজিনেশন করে দেবে, আজকে লিভ দিয়েছি করে bring your clerk and appropriately please stitch the application. কালকে লিস্টে দিয়ে দেবেন ওই সব কটা can application.
কিসের জন্য
আমি না
For who is appearing?
Oh, my lord, kindly takes it up next week.
No. First matter order of attorney. No. You're mentioning it as
yes, direction upon the respond. নাম দেওয়ার কথা ছিল to substitute. We have not been able to carry out the substitution because
Substitution hasn't been carried out any.
yes, the appellant mentioned the matter for order of attorney.
Yes, my lord, because the substitution could not be carried out. There was a previous order, my lord, from the Honorable Single.
The substitution application has been filed.
It's been allowed.
না substitution
There is no representation on behalf of the respondent today.
আমরা চিঠি লিখেছিলাম, ইমেল
Calling for the
করেছিলাম,
details
ডিটেল
of
দেয়নি
legal heirs
এখনো,
as-
that is why
I'm sorry. The legal heirs, my lord, the details had to be given under order 22 rule 10. We had asked for that. That has not been given. So if they give it, we'll file the substitution.
Yes, Mr.
Not in the execution proceeding, it was substitute. The appeal, the present appeal, which is pending, order 41 rule 11, is of 2005.
No, only the names of the.
Is executed.
But then they are wanting the names of the heirs and real representatives. And supply the names.
The execution is over.
Even then, they have 144 if they win the appeal.
The client, this order has not been communicated possibly. Yes,
No, Mr. Bandyopadhyay will only direct you to provide the names and particulars of the heirs. Then at senior counsel appearing for the appellant submits that no substitution application could be filed because the heirs, the particulars of the heirs and legal representatives of the deceased respondent number 2.
Yes.
Respondent, only respondent.
Respondent, only respondent.
This is respondent
As per order.
have not been supplied to the appellant. Full stop. Next para. Accordingly, the learned advocate for the respondent is requested to furnish the names and particulars of the heirs and legal representatives of the deceased respondent to the learned advocate for the appellant in writing by tomorrow.
My lord, it was already substituted in the execution.
Give a copy of that, serve a copy, but formally do it. The matter shall be listed next on December 15, 2025. Mr. Bandyopadhyay, point out and you can also oppose the substitution application on that ground.
Yes.
That it was already, it was within their knowledge.
By filing application.
They'll have to file an
I
application.
will have to file application.
They will have to file a substitution, their appeal. Within a week, you cannot file.
No, the other problem is whether your lordship would take it up or not. I don't
No,
know.
we won't.
It has to-
Sorry, last line যেটা বললাম যে we listed on সেটা কেটে দাও. Let the matter go out of the list with liberty to the parties to mention the substitution application, comma, if filed, comma, before the appropriate learned single judge having determination upon service of an advance copy of such application on the learned advocate for the respondent.
Yes.
Item number 5.
5, yes. Yes, move your matter.
My lord, I am appealing.
Yes. Caveat, copy. Service on the caveat.
My lord, no caveat.
এটা দিন ওনাকে। You are, who is Mr. Biplab Ranjan Bose?
My lord.
Your signature. Read it out. You have forgotten read out.
My lord, sorry.
Please read out what you have stated.
My lord, caveat has been received on 27/2/2023.
And then what?
My lord, I undertake to serve copy.
Then
my lord, extremely sorry.
it will go out of the list.
My lord,
Just go out of the list. Now,
my lord, not this week. I am praying for not this week, my lord.
despite the learned advocate on record for the appellant having endorsed in the connected stay application that a caveat has been received and he will serve a copy thereof on the caveator, comma, no such copy has yet been served. Full stop. Accordingly, the appellant shall serve a copy of the application along with a copy of the memorandum of appeal on the caveator respondent and file a receipt in that regard on the returnable date. Full stop. Let the matter be listed next on December 16, 2025. Tuesday, next.
Sir, grateful. My lord, in this matter, there is a mistake, my lord. My lord, instead of filing a CO, I have filed a SMA.
What is the impugned order?
My lord, the impugned order is in the first miscellaneous appeal granting injunction in favor of
Learned counsel for the appellant submits, comma, rightly, comma, that instead of a revisional application under Article 227 of the Constitution of India, comma, erroneously a second miscellaneous appeal has been filed. Full stop. We find that the impugned order was in the nature of an injunction order passed in a miscellaneous appeal under Order 43 of the Code of Civil Procedure, and, comma, as such, no second appeal is maintainable against such order in law. Full stop. Accordingly, SMAT 1 of 2025 is dismissed as withdrawn with liberty to the appellant to file an appropriate file an appropriate challenge against the impugned order before the appropriate forum stroke court. Full stop. Liberty is also granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy thereof for the records. Can 1 of 2025 stands disposed of accordingly, no rest to cost.
Grateful. But I am doing it here.
No, from the department. It will go down today itself.
Lord.
Because they have a formality, you'll have to put in that photocopy and
Lord.
7, yes.
At 7, I am for the
Malad, I appeal for the respondent.
Certified copy of judgment and
Malad,
degree of trial
yes,
court not filed, barred by limitation, classification of appeal wrong, preamble,
yes,
bereft of name of.
certain defects, my lord.
Remove those and come back. Where are the
Yeah.
certified copies of the judgment and degree of the trial court?
My lord, certified copy, probably, my lord, the
Trial court.
trial, first court of first instance.
That is generally called the trial court.
Trial court, my lord. Yes, my lord, that judgment and my lord, appellate court judgment, we have annexed, my lord.
We are only asking you where is the certified copy of
But
the
certified
judgment
copy,
and
my lord, my lord, I have given, my lord, instruction to the, I have given direction to the, my lord, trial court.
Unless you file that, we cannot take up under order 41. And what about limitation? You have filed a section 5.
Yes, my lord, section 5.
They have not given any copy of the.
My lord, no caveat, my
There is
lord.
no direction, that's why. They
have only served.
You mention again when you get the certified copies. We cannot wait indefinitely. Liberty is granted to the learned advocate on record for the appellant to rectify the defects as pointed out by the stamp reporter regarding the classification of the appeal and insertion of the name of the learned trial judge in the preamble of the memorandum of appeal by tomorrow. Please do these corrections by tomorrow. Push up next para. The appellant shall serve a copy of the condonation application on the learned advocate appearing for the respondent during the course of the day. Full stop. Next para. The matter let the appeal go out of the list with liberty to the appellant to mention for inclusion in the list again upon filing certified copies of the judgment and degree of the trial court in the department. Full stop. Upon such certified copies being filed, comma, the department shall give a revised report in that regard. File it, ask the department to give a revised report and then mention. And give a copy to them today.
Within.
Correction by tomorrow, do it by today. Yes.
Lord, here, my lord, 400 something days delay. My lord.
We have filed the honorable civil judge's copy of that, my lord.
Of what?
Of the office.
You all,
Only one copy was filed.
Please. 400 something. What is the ground, Mr.
My lord, ground is, my lord, kindly see, my lord. It is, there is a, my lord.
Is that an answer to our question?
Oh, sorry, my lord. I'm coming.
What is the ground we are just asking?
Yes, my lord.
Forgotten so many matters.
My lord, only one matter. This one matter.
So many matters you have.
My lord, kindly see, my lord, kindly come to my section 5 application.
You're there. Which paragraph?
My lord, kindly see. Just a minute, my lord.
We heard you have a template for this section 5.
Yes, my lord. Of course.
Yeah, we heard that you have a template for this section 5 applications. You insert that and just put in the days.
Yes, my lord.
So you should be.
My lord, 9. My lord, kindly see 11. Starts from 11, page 6, paragraph.
There, page 11. What is your ground? Tell us.
My lord, additional district magistrate dated such and such made a written proposal addressed to the learned legal remembrancer, that is 24, stating interior to the effect there are substance to prepare a second appeal such and such in the learned title such and such. The concerned official at the point of time intimated copies of the judgment decree as well as officer in charge and are also placed all before him for taking appropriate steps. It is after going through the record relevant he opined preferred a second appeal, and that too was subject to the approval of the higher authority and such and such and such. That fact, entire file along with the opinion of the such and such, and same was sent to the district magistrate on April as per records. It is the fact that material point the learned advocate Mr. Supratim Dhar was against. My lord, I am not blaming. I am not blaming anybody, my lord. But fact remains, my lord, it was the superannuated. After, my lord, however, at the time, the fact remains Supratim Dhar was overburdened because I am in favor. That because he was overburdened, that's why, my lord, it was not filed. Then, my lord, I have been engaged. But I think, my lord, subject to my lord's second kind approval, my lord, the grounds, my lord, I have made out.
400 something days delay for
Yes,
this.
my lord, because of the fact that appeal was not preferred, because advocate was appointed, my lord, but
No, 19th of December 2023, the judgment was passed.
yes, my lord, and my lord, the appeal was, my lord, Mr. Dhor was engaged, my lord, on 19th February 2025.
19th February 2025.
Yes, my lord, I have annexed. Page
That is
15.
2 years after.
Yes, my lord, because
For
my lord,
all this time, what happened?
approval, my lord knows that, my lord,
You
approval.
sack your law officer then.
Because I have
If
already.
your law officer
Yes, I have.
takes 1.5 years to give an opinion on
Yes,
this.
my lord, I have already.
Will impose cost on the law officer to be paid from his salary. Let him pay the salary from his pocket as cost to them.
My lord,
Where the state cannot suffer.
No, I am
State is public money.
My lord,
Mr. Sengupta.
I cannot open my mouth. Let there be a cost, my lord. My lord, I am not on that.
On the officer in charge law, because you have blamed him. He's a scapegoat.
My lord, scapegoat, because, my lord, it is fact. Because the first he was superannuated, then, my lord, he took charge. My lord, this is fact. My lord, I think, my lord, subject to my lord.
Yes, what do you say?
It is settled law, my lord. The length of delay is not one of the prime consideration.
No, but grounds have been given.
Lord, kindly have look, my lord, the judgment and decree was passed on 19/12/2023. But they highly contested the matter. They know the outcome of the appeal. Now, my lord, according to their statement, my lord, kindly have a look to paragraph 14. The approval was, my lord, granted in April 2024. Thereafter, my lord, nothing has been properly explained why the delay has been caused. And not only but it is not, my lord, the departments are, my lord, situated far away from one another.
You have not stated when Mr. Supratim Dhar was engaged.
Yes, my lord. My lord, kindly come to, my lord, I have annexed, enclose the, my lord, the copy of the appointment letter. That is page 15 of my section 5.
Page 20.
Page 15 of my section 5.
19th February 2025. You got your approval on April 2024.
Yes.
So what were you doing for these 10 months?
10 months, my lord, because, my lord, the officer was superannuated. Then, my lord, he comes.
When was he superannuated? You have not yet stated that.
Yes, my lord, in
What
the
is the
month
role
of,
the officer?
however, the material in the month of 2023.
Month of 2023?
23,
is not
the
a month.
then officer, that is paragraph 15, I have written. In the month of paragraph 15, page 8.
November 2023, he was superannuated.
Yes.
April 2024, the approval was given.
Yes.
So there was no person working in his place.
Because
we are concerned from April 2024. Mr. Sengupta, we can condone the delay up to April 2024. We understand that 19th of December 2023, the judgment was passed. April 2024, you take a decision. 4 months are taken for taking the decision. Appreciated. But after that, this person had retired in November 2023 before, 5 months before that.
I cannot open my mouth.
No, you have to open your mouth because otherwise your application will we'll have to open our mouth.
Kindly see, my lord, one thing, my lord. Kindly, subject to my lord, second kind of.
No explanation.
Entire file along with the opinion. My lord, kindly see, page 7, paragraph 14. Fact remains the entire file along with the opinion being formed of the officer in charge, additional district.
Yes, it culminates in granted in the month of approval, granted in the month of April 2024.
Yes,
so we condone up to that. What happened after that? What is the explanation? You say advocate Mr. Supratim Dhar was engaged. He was overburdened, but you have not given the date. You have annexed his appointment letter, which is of 19th February 2025. What were you doing from April 2024 to 19th February 2025? Not a single line of explanation here. Not a single line. We'll dismiss the appeal.
Malad, kindly consider one. Subject to again, Malad, kind approval.
Yes.
Malad, after all, Malad.
After all what?
After all, Malad, I am.
Who is responsible? Tell us.
Malad, kindly.
No explanation. Mr. Sengupta, you have settled this. Then we will impose the cost on you.
No, I will pay the cost.
We will impose it on you. I will record your submission that you have agreed. We'll record your submission that you have agreed to pay the cost. Because if you say that you are responsible before even you were engaged, then you pay the cost.
No, my lord. Before I have been engaged, my lord, then my lord cost.
Mr. Supratim Dhar was engaged in February.
I am not.
Let us complete our
No, my lord, I am not blaming. I am blaming.
We are not saying you are blaming. You are saying Mr. Dhar was engaged in February 2025. You were engaged after that. So how could you be responsible from April 2024 to February 2025?
There's some officers who has to be, my lord, take the responsibility. My lord, I have kindly.
No ground given.
Yes,
Why
my
should
lord.
he condone
Kindly,
it?
kindly pay the cost. I will pay the cost.
No, no.
My lord, kindly.
Dismiss the.
I don't know, kindly. Otherwise, my lord, kindly. My lord, then my lord.
Was appointed in November 2023, according to paragraph 15.
Yes.
Judgment was delivered on December 2023. Before passing of the judgment, he was appointed. He was engaged.
He was.
Have a look, paragraph 15. November 2023.
No, these are disjunctive sentences. That is bad drafting. It is a fact that at the material point of time, learned advocate Mr. Supratim Dhar was engaged. However, at the everything is material point of time.
In the month of the then officer in charge was engaged. My lord, but my lord, kindly consider.
They do not say that Supratim Dhar was engaged in November 2020.
Yes.
On that, in that month, that officer in charge law was superannuated.
He was superannuated.
But he was superannuated before the judgment, so it is not material at all.
My lord,
No explanation, no proper
my
explanation.
lord, may I submit? My lord, may I submit? Kindly, do not, my lord, kindly, if there is a merit. My lord, I am placing two judgments.
No.
My lord, placing two judgments. This is, my lord, my request. My lord, otherwise, my lord, kindly consider this.
All those judgments have become academic after the latest judgments of the Supreme Court.
My lord, that's why, my lord, I am placing. Subject to my lord's kind approval. There is a point.
We won't go into the merits.
Allow me for 2 minutes. Allow me for 2 minutes. This is 2012 5 SCC, my lord.
2012 is obsolete.
My lord, I am.
Now there are several judgments.
Now I will say that. I will say that. Kindly see this first, my lord. Paragraph.
These are academic, Mr.
My lord, it is not.
This is well settled all along. Show us the latest judgments of Justice Pardew. Please cite those judgments.
Yes, my lord, that is the thing. That's why I am saying.
Cite that thing.
Lord,
this is well settled. You need not cite any judgment before that.
My lord, what I am on, my lord.
No, you cite the latest judgments, Mr. Sengupta. You cannot dupe the court like this. No. Sorry.
My lord, I know.
You cannot suppress from the court the latest judgments. You cannot rely on 2012. Though there are latest judgments of 2024, 2025. Please cite
2024. Yes.
Cite those judgments right now.
My lord, they are.
Why are you relying on 2025? 2012.
My lord, 2012. My lord, why I am.
Please cite that. Immediately.
My lord, kindly see. Before that 2018. My lord, before that division bench of our.
These are of 2023, 2022.
My lord, I will make
2025.
2025, yes, my lord. I will make the distinction, my lord. I will make subject to my lord second kind approval. My lord, kindly read and my lord, kindly read this. Our
so many copies. So many copies.
My lord, 2 for Lordship.
2 for each of us.
No.
ঘাবড়ে যাচ্ছিস কেন তুই?
Yes, Mr. Sengupta.
My lord, kindly consider, my lord, first, my lord, let there, my lord, kindly, I have gone through that judgment. My lord, here, what I am on, my lord, kindly. My lord, there cannot be kindly consider,
yes.
2 parallel lines, there cannot be an ending point. What I am on,
what parallel lines, what ending point?
Parallel lines in the sense, one is saying that if the merit is there, then liberal construction to be made. And another is that the public and the private and the state are in the same pedestal. That cannot be, according to Supreme Court judgment. Because,
yes,
judge shown. My lord, kindly consider one thing, my lord. Kindly see these judgments which I am relying upon. These are not overruled by this judgment.
Very well, cite the judgment.
2015, paragraph 17. 2012, first, my lord, kindly come.
Yes.
Paragraph 17. My lord, what I am on? Paragraph 17, my lord, I have handed over. My lord, what my submission would be twofold. First of all, if the limitation, the section 5, is based upon what? My lord, I will show that from the judgment. And this judgment is still remains, it has not been overruled. My lord, kindly see paragraph 17 of my lord, I have handed over, my lord. I may be wrong, but my lord, after all, my lord, there is a merit in this case, my lord. Otherwise,
yes, paragraph 17.
Yes, paragraph 17. In Calcutta, this made a this court, this honorable court, made a significant departure from the earlier judgments observed as well. Legislature has conferred the power to condone the delay by the enacting section 5 of the limited line in order to enable the courts to do substantial justice to parties by disposing of the matters on merits. Now, my lord, this is point. The expression sufficient cause employed by essay adequately elastic to enable to apply the law in a meaningful manner and which subserve the ends of justice, that being life purpose of the existing institution of courts. It is common knowledge this court has been making a justifiable liberal approach in matters institutional, but the message does not appear to be particular down to all other courts in its hierarchy. And such a liberal is adopted on the principle as realized. But kindly consider, every day's delay must be examined does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? Doctrine must be applied in rational, common sense, pragmatic manner. Refusing to condone the delay, kindly refusing to the result in a meritorious matters being thrown out at the threshold and cause of justice has been defeated. This logic, my lord, kindly consider, visualize. This cannot be, my lord, my respectful submission would be, this judgment has not been overruled by the subsequent judgment. My lord, my humble submission would be, if there is a merit, my lord, kindly look at the merit. If there is no merit, kindly throw me out. My lord, kindly, that is because this judgment still remains, it based upon the section 5 bis matters on, that is this, the merits.
Yes.
My lord, kindly consider one another thing. My lord, here the judgment, my lord,
Other judgment, Mr. Shen.
another judgment, yes, my lord.
Cite.
I will cite, my lord. Yes, my lord. This is our honorable duty because of where I appeared, my lord, on behalf of the state, my lord. Yes, madam. Kindly come to paragraph page, and this is our. Yes. Well, I think this is reported, but well, right now I do not recollect. But even I didn't search it. I should be candid to my lord.
Which paragraph?
Well, kindly come to paragraph 5 and 8.
There are no paragraph numbers here.
Sorry. Sorry, page. Sorry, my lord.
Yes, 5.
Page 5, my lord. In Chand, my lord, can I kindly see before that, my lord, the it is axiomatic, my lord, kindly see. Esha Bhattacharya, Supra 2005. It is axiomatic, that is kindly turn over the page 4.
Yes.
Starting second paragraph. While reading the decisions in Malad got it? Esha Bhattacharya.
Yes, we're reading it.
Yes. We find that the decision reported in such and such was considered in paragraph 15. It has been here as follows. It is axiomatic that the decisions are taken by officers, agencies, probably at a slow pace. An encumbered process and pushing the files from table to table and keeping it on the table of the considerable time causing delay, intentional or otherwise, is a routine. Considerable delay of procedural red tape in the process of their making decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeals brought by are lost for such default, no person is individually affected. Well, kindly note it down. But when the ultimate analysis suffers is public interest. That is my submission, respectful submission before my lord. The expression sufficient cause should therefore be considered with pragmatism in a justice-oriented approach rather than technical detection of sufficient for explaining every day's delay. The factor which are peculiar to and characteristics of the functioning of the government conditions would be cognizant to and requires adoption of pragmatic approach in justice-oriented process. The court should decide the matters on merits. Again, my lord, on merits, unless the case is hopelessly without merit. This is my submission, my lord. If my lord kindly consider my appeal, if there is a merit, kindly accept. If there is no merit, according to my lord's opinion, my lord, throw me out. After what? Who will suffer? Public will suffer, my lord. My lord, this judgment, my lord, merits this judgment, my lord, and my lord, there also, the other side, my lord, cited all to other judgments also. Their state and they are on the same pedestal. My lord, this approach, I think, my lord, this is I should not say that, but it is contrary to the principles laid down already in the Supreme Court judgment, various Supreme Court judgment. And this has not been, neither of the judgment has been overruled by the latest judgment. My lord, kindly consider, my lord, this is not for me. This is for public in general. I am appearing for the state, my lord. My lord, the callousness of the officers, for that, my lord, no, after all, who will suffer? Public will suffer. My lord, kindly, that's why, my lord, I am opening with my humble submission that two cannot go simultaneously. The honorable latest judgment says that state and the private party should be at the same pedestal, and there should be justification, every justification. But my lord, where is this judgment? This has not been overruled. Here, merit, my lord, kindly see, scuttle. My lord, if the merit is there, scuttle it, even it is written. My lord, kindly see. This is, my lord, disposed of. My lord, this, not that, but it is interim. This is disposed of. Kindly see. So, my lord, I am not here for any individual. My lord, kindly think in that way. And, my lord, kindly see the latest judgment I have gone through. What I am, because I got the opportunity to appear before my lord. Because these judgments are not being overruled by this judgment. I could have understood that this is a larger bench. This has been overruled. But, my lord, kindly think this approach and the latest approach by the Honorable Apex Court. This cannot go simultaneously. These parallel lines, in mathematics, in parallel physics, parallel lines cannot meet.
Mathematics or physics? First decide.
Physics. Physics. Do parallel lines. One is that
you're not showing parallel lines. You're touching the lines.
Well, that only consider what I am.
These cannot be parallel lines. These can be parallel.
Yes.
Yes.
My lord, only one thing, my lord. I am for the state, my lord. I am for the public, my lord.
Be proud of that.
Yes,
be proud of that. Carry your pride to your officers.
My lord, yes, for cost, pay cost. But, my lord, kindly see the merits at least. Within a minute, my lord, kindly, I can satisfy there is a merit. Absolutely perverse. Maybe it is judgment on affirmation. But this is one case. They will come, they will be flooded, there will be so many cases will come up. Because of this. Because the learned appellate court first relied upon a judgment passed by this honorable court, which held the quashing of that notification. That's why it is applicable to entire case.
Well, let us hear them.
Yes.
Yes.
My lord, what my learned friend has submitted, my lord.
No, there are other judgments also
Latest judgment, my lord.
where it has been held that merits cannot be considered.
Yes.
Paragraph 5, my lord.
Paragraph 5 of
Paragraph 5. Paragraph 5, my lord. Even though limitation may harshly affect the rights of a party.
Paragraph 5.
My lord, of that judgment, my lord.
This is Union of India versus Jahangir. This you have
The state of Madhya Pradesh versus
that you have not handed over.
And latest judgment দেখাও না latest judgment ওখানে বলা নেই merited
2025 volume 1 Indian civil cases.
No, you have given only one copy of them. You took the other copies. There are several judgments.
2025 volume 1 Indian civil cases 752.
No, I'll give all the other copies also. I have got only Union of India, Jahangir, and this Madhya Pradesh.
Sir, one after another, I will rely upon the judgment. First of all,
Madhya Pradesh first.
First, Madhya Pradesh.
Para 5.
Para 5. Para 5 and 6, my lord. Every answer has been given by the honorable people. The legal position is that where a case has been presented in the court beyond limitation, the petitioner has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In Marji Sanana versus Reddy such and such, it was held by this court that even though limitation may harshly affect the rights of a party, it has to be applied with all rigor when prescribed by the statute. A reference was also made to the decision of this court in Oja Dabra versus Pairam 2023 SCC Online SC, wherein it was held as follows. This court in the case of Basura Judge Special Land Acquisition Officer 2013, while rejecting an application for condonation of delay for lack of sufficient cause, has concluded in paragraph 15 as follows. The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on its part in the facts and circumstances of the case, or found to have not acted diligently or remain inactive, there cannot be a justified ground to condone the delay. No court should be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on time, condoning the delay without any justification, putting any condition whatsoever, amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing utter disregard to the legislature. Therefore, you are of the considered opinion that the High Court did not commit any mistake in dismissing the delay condoning application of the present applicant. Thus, it is crystal clear that the discretion to condone the delay has to be exercised judiciously based on facts and circumstances of each case, and that the expression sufficient cause cannot be liberally interpreted if negligence, inaction, or lack of bona fide is attributed to the party. In Union of India versus Jahangir, wherein one of us was a member, after referring to various decisions on the issue, it was an unequivocal terms observed by this court that delay should not be excused as a matter of generosity, and rendering substantial justice is not to cause prejudice to the opposite party. The relevant passage of the same is probably accepted below. In the aforesaid circumstances, we made it very clear that we are not going to look into the merits of the matter as long as we are not convinced that sufficient cause has been made out for condonation of delay of such long inordinate delay. It hardly matters whether a litigant is a private party or state or Union of India when it comes to condoning the gross delay of more than 12 years. If the litigant chooses to approach the court long after the lapse of the time prescribed under the relevant provisions of the law, then he cannot turn around and say that no prejudice would be caused to either side by the delay being condoned. The litigation between the parties started sometime in 1981. We are in 2024, almost 43 years have elapsed. However, till date, the respondent has not been able to reap the fruits of his degree. It would be a.
Yes, what are the other judgments you cite?
Now, my lord, the paragraph 6. At the same time, we cannot simply brush aside the delay occurred in preferring the second appeal due to careless and lackadaisical attitude on the part of the officials functioning in the state machinery. Though the government adopts systematic approach in handling the legal issues and preferring the petitioner's applications appeals well within the time, due to the fault on the part of the officials is merely communicating the information on time, huge revenue loss will be caused to the government exchequer. The present case is one such case wherein enormous delay of such and such days occasion in preferring the second appeal due to the lapses on the part of the officials functioning under the state, though the valuable government lands are involved. Therefore, we direct the state to streamline the machinery, touching the legal issues, offering legal opinion, filing of cases before the tribunal, courts, etc., fix the responsibility on the officers concerned, and penalize the officers who are responsible for delay, deviation, lapses, if any, to the value of the loss caused to the government. Such direction will have to be followed by all the states scrupulously. Now, my lord, this application was, my lord,
Yes.
But paragraph 7 is also very relevant, my lord. There is one other aspect of the matter which we must not ignore or overlook. Over a period of time, we have noticed that whenever there is a plea of condonation of delay, be it at the instance of a private litigant or state, the delay is sought to be explained right from the time the limitation starts, and if there is a delay of say 2 years or 3 years or 4 years till the end of the same. For example, if the period of limitation is 90 days, then the party seeking condonation has to explain why it was unable to institute the proceeding within the period of limitation. What events occurred after the 91st day 91st day till the last date is of no consequence. The court is required to consider what came in the way of the party that
Yes,
it was.
sir, we have seen it.
No, my lord.
Yes,
Yeah, my humble submission before your lordship, my lord, that no proper explanation has been, my lord, rendered by the state that why this redundant delay was called. And my lord, only taking the plea of that if merit, the case has got merit, so delay can be condoned. But I put this question to myself: if state comes after 5 years, 6 years, and state, yes, there is merit, you have the delay should be condoned. But the statute has, my lord, casted an obligation upon all the parties to, my lord, prefer any, my lord, proceeding within a limitation period. That's why, my lord, the application of limitation act is there, my lord. Otherwise, my lord, anyone can come at any point of time and say, I would be prejudiced if the delay is not condoned. So, my lord, I am, my lord, relying upon another judgment, my lord. That is, my lord, reported in, my lord, 2022 volume 1 Indian Civil Cases 759. My lord, paragraph 7. May I read for your lordship, my lord?
Yes.
At this stage, a few decisions of this court on delay in filing the appeal are referred to and considered as under. In the case of Ramlal, Motilal and Chotela, it is observed and held as under. In construing section 5, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of the period of limitation prescribed for making an appeal gives rise to a right in favor of the decree holder to treat the decree as binding between the parties. In other words, when the period of limitation prescribed has expired, the decree holder has obtained a benefit under the law of limitation to treat the decree as beyond challenge. And this legal right, which has accrued to the decree holder by lapse of time, should not be lightheartedly disturbed. The other consideration which cannot be ignored is that if sufficient cause for excusing delay is shown, discretion is given to the court to condone the delay and admit the appeal. This discretion has been deliberately conferred on the court in order that judicial power and discretion in that behalf should be exercised to advance substantial justice. As has been observed by the Madras High Court in Krishna, Section 5 gives the court a discretion which in respect of jurisdiction is to be exercised in the way in which the judicial power and discretion ought to be exercised upon principles which are all understood.
We have seen it. We have virtually the same things as.
My lord.
This was also quoted in the other
My
chapter.
lord.
Para 7.4 was quoted in the other
My
chapter.
lord.
Yes.
Now, my lord, para 8. Applying the law laid down by this court in the opposite.
In that case, facts of the case were reversed. Yes. Seen it. Anything, any other judge? These are sufficient probably. Yes, we'll pass our orders.
Only one thing, my lord, only one thing. My lord, page 15 of my stay application, this is, I am wrong, my lord, actually I was wrong. My lord, 19th February 2025, that appointment was made in the year 2023 in favor of Supratim Dhar. And but my lord,
In a
here
section
I
5
have
application, it is not there.
my lord, yes, I have stated.
You have annexed in page.
Yes, page 16, I am directed to inform you. In addition to Mr. Supreme Dhar, State Advocate with the junior has been engaged in the matter with that is, my lord, official address to Mr. Sushokon Sengupta. My lord, in addition, because 19th February 2020,
You have not stated in your application when Supreme.
yes, Supreme Dhar, I just pointed out in the November 2023, month of November, because
You have
it
not
is not
stated
in
that
the
in November.
yes, November 2023. My lord, and kindly see, it is a fact at a material point of time because I did not collect the copies of that appointment of Mr. Dhar. It is at the material point of learned advocate Mr. Sumer was engaged for preferring the instant second appeal on behalf of the. However, at the material point in the month of 20, the then officer in charge was superannuated and afterwards.
You have not stated. You have stated
yes,
it is a fact that at the material point
of time, because when
material point of time is not explained.
Explain, Melody. I admit
You have
because I did
stated
not.
that it is a fact that at the material point of time, learned advocate.
But it must be
Mr. Sengupta, when we are speaking, you won't speak. You listen. It is a fact that at the material point of time, the learned advocate Mr. Supratim Dhar was engaged for preferring the instant second appeal on behalf of the state of West Bengal. We don't know what is the material point of time. Then you say, however, at the material point of time, that is in the month of November 23, officer in charge superannuated. November 2023 is even before the passing of the judgment. So if you take the material point of time to be November 2023, how could Mr. Dhar be engaged before the judgment being passed?
My lord, may I give a
Judgment is passed in December 23. You engage Supratim Dhar in November 23. Are you joking with the court, Mr. Sengupta? Has the state stooped down to such a low level?
No, my lord. I think, my lord, this is properly.
Keep your thoughts to you.
Yes, my lord. This has not been written in a proper way.
Ashun.
My lord, only one thing, my lord.
The present application for condonation of delay in preferring the second appeal is in respect of a delay which has been stated to be the additional stamp reporter to be of 356 days, comma, but mentioned in the application for condonation of delay by the appellant state as 503 days. Full stop, however, comma, even going by the lesser number, comma, we find that no explanation what the name has been given in the application for the delay in preferring the same. Full stop, next para, and senior government advocate, comma, appearing for the state, comma, seeks to argue that one, Mr. Supratim Dhar was engaged as an advocate to conduct the second appeal in the month of November 2023, comma, in which month the concerned officer in charge within bracket law / additional land acquisition officer in charge of the matter was superannuated. Full stop. Next para. It is further contended by learned senior government advocate that while adjudicating condonation applications, comma, the court ought to adopt a liberal approach. Full stop. It is also submitted that the second appeal itself has sufficient merits, comma, which ought to be considered at the time of condoning the adjudicating the condonation application. Full stop. Next para, in support of his contentions, comma, learned senior government advocate cites a division bench judgment of this court rendered in the matter of MAT 1447 of 2017. Full stop. Next para, learned senior government advocate also relies on Moneyben such and such reported at 2012 5 SCC 157. Full stop. Next para, learned counsel for the respondent submits that that no plausible explanation has been given for the huge delay in preferring the appeal. Full stop. Next para, it is pointed out that the court has been sought to be misled in paragraph 15 of the condonation application, where it has been stated that the concerned officer in charge had been superannuated in November 2023. Full stop. However, comma, the impugned judgment of the first appellate court was itself passed on December 19, 2023, that is much thereafter. Full stop. Hence, comma, it could not be that an officer in charge was entrusted to prefer the present second appeal even before the impugned judgment was passed. Full stop. Next para, learned counsel for the respondent, comma, in support of his contentions, comma, cites such and such reported at 2025 1 Indian Civil Cases 753 bracket SC নামগুলো দিয়ে দেবেন bracket, comma, 2024 4 Indian Civil Cases 783 within bracket SC and 2022 within bracket 1 ICC 759 bracket SC. Full stop. It is contended, comma, by citing the said judgments, comma, that inaction or lack of bona fides on the part of the appellant cannot be liberally construed, comma, where there is clear negligence on the part of the appellant in occasioning the delay in preferring an appeal. Full stop. Moreover, comma, it was observed that even though limitation may harshly affect rights of a party, but it has to be applied with all its rigor when prescribed by statute. Full stop. Negligence, lack of bona fides and inaction cannot be any justified ground for condoning the delay. Full stop. Next para, it is further contended that the Honorable Supreme Court has held in the said judgments that the merits of the main matter cannot be looked into prior to the appellant crossing the hurdle of condonation of delay. Full stop. Next para, we find substance in the contention of the respondent. Full stop. In the application for condonation of delay, comma, in paragraph 11, comma, it has been categorically stated that the impugned judgment and decree of the first appellate court was passed on December 19, 2023. Full stop. Next para, it is stated in paragraph 12 that concerned officials of the appellant at that point of time to double inverted mode intimated the copies of the judgment and decree as well as the records to the higher authority, that is the officer in charge within bracket law and additional land acquisition officer, comma, North 24 Parganas, and also placed all relevant records before him for taking appropriate steps regarding that. Full stop. Next para, in paragraph 13, comma, it is stated that the said law officer opined for preferring a second appeal, comma, that too, comma, subject to the approval of the higher authority. Full stop. Further, comma, it is stated that the learned government pleader, comma, Barasat was contacted for seeking his opinion. Full stop. Next para, in paragraph 14 of the condonation application, comma, it is boldly stated that the entire file along with the opinion formed by the then officer in charge within bracket law was placed before the special land acquisition officer, and in turn the additional district magistrate within bracket LA took into consideration such proposal, and the same was sent to the district magistrate, comma, North 24 Parganas for his proposal, and approval was granted in the month of April 2024 as per records. Full stop. Next para, surprisingly, comma, in paragraph 15, comma, it is stated that double inverted mode at the material point of time, double inverted close, comma, the learned advocate Mr. Supratim Dhar was engaged for preferring the instant second appeal on behalf of the state of West Bengal. Full stop. It is further stated that, comma, however, comma, at the material point of time, our material point of time to double inverted, that is in the month of November 2023, comma, the then officer in charge within bracket law was superannuated and afterwards was again re-employed and directed by the higher authority to officiate the same post of land acquisition within bracket law cell stroke additional land acquisition officer of the appellant herein. Full stop. Next para, in paragraph 16, comma, it is stated that the said Sri Supratim Dhar, comma, advocate was overburdened, double inverted mudde, since he was appointed in various cases where the state was involved, and that there was a vacuum near about 4 months for making necessary arrangements as well as giving proper instruction to the said learned advocate, for which the said learned advocate was not in a position to prepare the draft of the memorandum of appeal as well as connected applications. Full stop. Next para, however, comma, the present appeal has been filed only on May 8, 2025, comma, that is much thereafter. Full stop. The state does not explain the reason for the double inverted with the vacuum in making necessary arrangements and giving instruction to the learned advocate who was engaged. Full stop. Next para, more importantly, comma, a drastic misstatement has boldly been made in paragraph 15 of the application. Full stop. It has been stated that double inverted mode at the material point of time, double inverted close, comma, which has been specified to be the month of November 2023, comma, not only the said Mr. Supratim Dhar was engaged for preferring the instant second appeal, but that the concerned officer in charge within bracket law, comma, who was entrusted to prefer such appeal, comma, was superannuated. Full stop. However, comma, surprise upon surprise, comma, the judgment of the first appellate court, which has been impugned in the present second appeal itself, was passed in December 19, 2023, comma, that is, comma, even after Mr. Dhar and the officer in charge within bracket law was allegedly entrusted to prefer the appeal. Full stop. This is a prime example of putting the cart before the horse, where the officer in charge within bracket law and the concerned advocate apparently were engaged to prefer an appeal against a judgment which had not seen the light of day when the entrustment occurred. Full stop. Such palpable and gross misstatement is strongly deprecated by this court. Full stop. Next para. Hence, comma, the malafidez in the present application is evident. Full stop. Next para. We find from the application that no explanation at all has been given for the prolonged delay of about a year in preferring the appeal. Full stop. Next para. The reliance of the state on the judgments cited by it are also misplaced in view of the latest judicial opinion on the subject of condonation of delay. Full stop. Next para. The state relies on a coordinate bench judgment of this court in Port Shramik Cooperative Limited, Cooperative Supra, comma, where the said division bench had observed that a caution was sounded by the Supreme Court in respect of impersonal machinery and inherited bureaucratic methodology imbued, IMBUED, with the note hyphen making, comma, file pushing and passing on the buck, BUCK, ethos, ETHOS, resulting in belated presentation of appeals by the state. Full stop. Next para. The division bench also observed that in the said case, comma, when there was no gross negligence or deliberate inaction or lack of bona fides, comma, the delay was condoned. Full stop. Next para. However, comma, as opposed to the said case, comma, in the present case, we find not only lack of bona fides, but also utter negligence, which is totally unexplained. And, comma, over and above the same, comma, the malafide attempt to mislead the court by giving false dates, which could not evidently be correct in the light of the above observations rendered by us. Full stop. Next para. The state has also relied on Maniben Devraj Supra, where the Honorable Supreme Court had itself observed, comma, inter alia, comma, that even though a liberal and justice-oriented approach is required to be adopted in the exercise of power under Section 5 of the Limitation Act and other similar statutes, comma, the courts can neither become oblivious of the fact that the successful litigant has acquired certain rights on the basis of the judgment under the challenge, and a lot of time is consumed at various stages of litigation apart from the cost. Full stop. Next para. It was also held that what color the expression double inverted sufficient cause would get in the factual matrix of a given case would largely depend on bona fide nature of the explanation. Full stop. Next para. The Honorable Supreme Court went on to observe that no premium can be given for total lethargy or utter negligence on the part of the officers of the state and or its agencies instrumentalities, and the applications filed by them for condonation of delay cannot be allowed as a matter of course by accepting the plea that dismissal of the matter on the ground of bar of limitation will cause injury to the public interest. Full stop. Next para. As opposed thereto, comma, in State of Madhya Pradesh versus Ram Kumar Chowdhury, reported at 2025, bracket Supra, comma, the Honorable Supreme Court categorically observed, comma, by relying on its previous judgment in the matter of Jahangir Bairamji Supra, comma, that the Supreme Court was not going to look into the merits of the matter as long as it was not convinced that sufficient cause has been made out for condonation of such a long and inordinate delay. Full stop. Next para. Such observation categorically takes care of the submission of the state in the present matter before us that the second appeal has substantial merits, which is to be factored in while considering the condonation of delay. Full stop. Next para. Going forward, comma, the Supreme Court further observed in Ramkumar Chaudhary Supra that if the litigant chooses to approach the court long after the lapse of the time prescribed under the relevant provisions of the law, comma, then he cannot turn around and say that no prejudice would be caused to either side by the delay being condoned. Full stop. It was held that while considering the plea for condonation of delay, comma, the court must not start with the merits of the main matter, but owes, OWES, a duty to first ascertain the bona fides of the explanation offered by the parties seeking condonation. Full stop. It was observed by the Honorable Supreme Court that due to callous and lackadaisical attitude on the part of the officials functioning in the state machinery, comma, the delay occurred cannot be simply brushed aside. Full stop. It was held that though the government adopts systematic approach in handling legal issues, comma, due to the fault on the part of the officials in merely communicating the information of time, comma, huge revenue loss would be caused to the government exchequer. Full stop. The Supreme Court thus directed the state to streamline the machinery touching legal issues, comma, offering legal opinion, comma, etc. Full stop. Next para. We find a reflection of the same view in Jahangir Bairamji Supra, comma, which was also considered in Ramkumar Chaudhary's case. Full stop. Next para. In Majji Sannemma Supra, comma, the Honorable Supreme Court, comma, while relying on a previous judgment of the Supreme Court in Basavaraj and another versus Special Land Acquisition Officer, reported at 2013-14 SCC 81, comma, observed that the expression sufficient cause, double inverted mode sufficient cause, cannot be liberally interpreted if negligence, comma, inaction or lack of bona fides is attributed to the party, and that even though limitation may harshly affect rights of a party, comma, it has to be applied with all its rigor when prescribed by statute. Full stop. It was further observed that in case a party has acted with negligence, comma, lack of bona fides, or there is inaction, then there cannot be any justified ground for condoning the delay even by imposing conditions. Full stop. It was observed that each application for condonation of delay has to be decided within the framework laid down by the court, and that if courts start condoning delay where no sufficient cause is made out by imposing conditions, then that would amount to violation of statutory principles and showing utter disregard to legislation. Full stop. Next para. In view of the above observations, comma, we are of the opinion that no explanation whatsoever has been made out in the condonation application in the present case, semicolon, rather, comma, an attempt to mislead the court has been made in the application as discussed above. Full stop. Next para. We also cannot forget the age-old maxim that the state cannot be considered to be a favored litigant over the citizens of the state. Full stop. Next para. Proceeding from such premise as well, comma, we do not find any reason whatsoever to condone the delay in preferring the second appeal. Accordingly, can 1 of 2025 is dismissed on contest without any orders to cost. Full stop. Consequentially, comma, SAT 112 of 2025 is dismissed as time barred. Full stop. The connected application being can 2 of 2025 stands consequentially dismissed as well. No orders to cost.
Obliged.
Thank you. Next. Yes. Yes, Mr.
Trial court judgment. The trial court judgment degree was not filed at the time of filing of the. I'm filing the same, my lord.
That was the only defect.
What I should do?
Section 5.
Section 5 day.
Appellate court's decree not in form has to be sent down. Certified copy you're giving now. All is sir. Very good. The certified copies of the judgment and decree of the trial court filed today be kept on record. Full stop. Accordingly, the defect in that regard is deemed to stand cured. The appeal is taken up for hearing under Order 14 Rule 11 of the Code of Civil Procedure. Yes. What is that?
Well, the plaintiff is the appellant before your lordship.
One second. The the file shall be sent down to the trial court for effecting necessary corrections to the impugned decree of the appellate court in terms of the additional report at the earliest. Yes.
Well, the plaintiff is the appellant before your lordship. Suit for declaration a deed executed in favor of the defendant is void and inoperative.
Both courts or?
Both courts. Nur Muhammad Sheikh was the original owner of the property.
It was of deed of?
Deed of sale.
Sale. That was void and inoperative. On what ground?
That Muslim হেবা বানাতে to sell. That the deed was not executed by the person.
Hiba then it's
no hiba, my lord. If you logically consider hiba is a transfer in that sense also. Hiba was if something is given in lieu of hiba, then my lord it akin to
sale from any point of view.
No consideration in that sense, my lord. Be as it may, my lord, registered document is there. Now, my lord, I am saying that this person who have executed the deed is not the person. By false falsification, such deed was obtained by the defendant. On that score, I filed a suit.
Your predecessor had executed?
Yes. We are also getting the property by way of
inheritance.
Not inheritance, but also by way of registered documents. That those
person.
By same person, but those are executed subsequently.
So not your predecessors as such, family.
Both are claiming through instrument.
Gifted first to them, then sold to you or hiba.
Hiba.
Very good. So their deed is false and yours is correct.
Yes. My lord, if you logically turn to the Nur Muhammad Sheikh was the original owner of the property. My lord, he executed the deed in favor of the defendant on 22nd February 2010. And that deed was ultimately registered after the death of the executor.
When?
It was registered on 21st March 2010.
When did he die?
He died on 22nd February 2010.
On the date of the gift?
No, deed was executed on.
You said he.
I beg to correct it. 9/4/2001. I beg to correct it, 9/4/2001. Sorry, I beg to correct it. 9/4/2001, the deed was executed. The deed was registered on 21st March 2010, and Nur Muhammad Sheikh died on 21st March 2010.
He died on 22nd February 2010.
No, 21st March 2010.
If he died on 21st March 2010, then the registration was before his death.
After his death, subsequently, my lord, logically consider February.
Probably 9th of April 2001, Hiba was
executed
and registered. Only executed.
Executed.
22nd February he died, and 21st of March 2010 registered. Check up.
No.
Expired ডেটের আগে registered
2010 21/3/2010 হ্যাঁ
as per plaintiff 22
registered কবে রেজিস্ট্রেশনটা
আগে হয়েছে registered. It was registered before his death. Mr. Rai, get prepared in your matters, please. You're moving an order 41 matter. This is the way you argue. It's recorded in the judgment that the deed of gift was registered before. 22nd of February 2010 registered, died on 21st of March.
16th, it is 16th April 2010, it was registered.
This is what trial na. Come to page 2 of the trial court.
Yes, my lord. He died on 21st March 2010. My lord got it.
We got it. You got it.
Yes, my lord. He died
It
on
was registered before his death on 22nd of February, as per your case.
As per the plaintiff 2010, through a registered deed, the said Nurbox gifted the properties under LR to my lord, dear lordship, to whom it was transferred.
Please
To
come
plaintiff
page,
number 1 to 3.
please come to page 2 of the trial court.
Yes, my lord. These
There this 10th sentence from the top. It's
Yes.
your case that it was registered on 22nd of February 2010,
yes.
and he died after that.
Yes, this is the deed which was executed in our favor. My lord, may I read? The said Nurbox gifted properties, that is 9 decimal from LR plot number such and such.
So what is the date of their gift and what is the date
That
of
deed was executed on 9/4/2001. Their deed. He died on 21st March 2010. The plaintiffs executed the deed of gift in our favor is 22nd February 2010.
So 1 month before his death, he executed.
Yes.
It. And when was their deed registered?
After 16th April 2010.
As per section 47,
It will relate back to the date of the execution.
that prevails.
That.
But
Now, my
you say
lord,
that's a suspicious circumstance.
not only the false false certification. My case was the false false certification.
Factual question.
Only one thing, that
Totally
both the
false
courts
person-
below held that the person during his lifetime did not challenge the deed. Not only that, a registered document presumed to be a correct document. Therefore, the allegation. This is so. What the my lord, the person, the deed surfaced after the death of that person. It got registered sometimes after his death.
If you could you prove your case that it was false personification? You have to prove it on facts by evidence.
Yeah, we have said that deed was executed in our favor.
You say that it
Deed was executed in our favor. We have recorded our name in the record of rights. In the Mohammedan law, my lord knows better than us, my lord. So, but the deed, irrespective of fact, whether registered or unregistered, delivery position is mandatory. If I can show that pursuant to the deed of gift, our name was registered in the LR record of rights, then the delivery position is the main thing for the purpose of holding that the effective deed was executed.
Whatever, Mr. Rai, if you could not prove your positive assertion that it was false personification, then you have no case.
Yes, if that be so, my lord, can you consider the deed of gift presupposes the coupled with delivery of position in Mohammedan law. If
It was the deed of gift in their favor.
yes, so both deeds are coming, my lord. One registered after his death, be as it may, it will relate back to the date of execution.
47.
47 of the Registration Act. Now, my lord, that be so, if my deed is there and the position is delivered to me and the record of rights is created in my favor, presupposes the delivery of position in my favor. So, what are the documents they produced for the purpose of, and can you consider how the learned trial court has considered this aspect? If your lordship can you consider internal page 7 of the trial court judgment.
Yes. Very illegible, this photocopy you have given. Today you have given.
Yes, certificate copy I have.
Appeal to illegible.
The appeal court is much more legible, my lord.
Trial court page 7, your certified copy will tally with this, which you have given. No, it does not.
No, it is subsequently it was obtained.
It's a own certified copy, the tally korbe na page number.
Page number might not be tallied, my lord.
You can't read anything of the last paragraph. You read out, we will follow. Yes. In any event, since the fate will be
the same. Yes, it affected.
No, Mr. Rai, place it.
My lord, may I place, my lord?
22nd February 2010, we can decipher this date only from this last. You read out for us what is the sentence.
No, my lord, I am reading from previous page. Since an original relief.
Page number?
It is internal page 6. Just after the exhibit lists have been mentioned, after that. Well, the exhibit lists are there.
Absolutely indecipherable. Can't read anything.
May I get a legible copy?
We'll follow from this.
Just the exhibit list has been mentioned by the trial court. After that, since a original.
ওটা আপনার ট্রায়াল কোর্টে কি আছে তাহলে আমি এখান থেকে ফলো করে নিচ্ছি আপনি ওখান থেকে ফলো করেন আমি এখান থেকে দেখে নিচ্ছি yes what is the sentence since
An original relief. Well, I got it.
yes please
The plaintiffs have prayed for a specific declaration that the court scheduled impugned deed gift heba is void and unenforceable. To this mind of this court, the veracity of said deed of gift is required to be assessed as outstage.
spend a little bit more in photocopying don't keep the entire thing to you
My lord, we have the my lord knows.
you see our photocopy must be some compromise in payments the cheaper ones you have approached yes so cost schedule let us come back to cost schedule
Court schedule impugned deed of gift is void and unenforceable. To the mind of this court, veracity of the said deed of gift is required to be assessed at the outset. As aforesaid, the plaintiffs disputed the genuineness of the said impugned deed of gift on the allegations inter alia that the same had not been executed by Nur Muhammad Sheikh and LTIs of the executor as the appearing on the said deed are not of the Nur Muhammad Sheikh's disease. As per section 101 of the Evidence Act, whoever desire any court to give any judgment on legal right or liability dependent on the existence of facts which he asserts, but prove that those facts exist. This section further says, when a person is bound to prove the existence of any fact, it is the said burden of proof lies on that person. Thereafter, section 102, my lord, I am skipping over the last portion, that portion. Now, my lord, can you turn to the, in other words, burden of proof? My lord will find 3-4 lines after.
yes
Primarily lies upon the plaintiff to prove that on 9/4/2001, Nur Muhammad Sheikh, since disease did not put.
Mr. Rai, is there a legal bar in registration happening after death
No, within 4 months.
can be,
it
within
can
4
be.
months it can be done
It can be
and it was done within 4 months
With February and April, my lord. Nur Muhammad Sheikh did not put his put LTIs on court scheduled deed of gift, and the same some other person appeared before the authority of the concerned registry officer falsely representing him. Nur Muhammad Sheikh performed the task of the execution of said impugned deed. But at this stage of evidence on behalf of all the plaintiffs, plaintiff of 4, only evidence the pleadings of the plaintiff orally, as pleaded one besides him, a common relative such as his deposed, just to corroborate that Nur Muhammad Sheikh, since disease had gifted the suit property to the plaintiffs, and the plaintiffs are in possession of the suit property. Therefore, the evidence on record, even there is no circumstantial evidence to make out a preponderance of probability that on 9/4/2001, the said Nur Muhammad Sheikh did not put LTI in the impugned deed of gift executed in favor of the defendant. Someone else appeared. Pause here for a moment. We have filed an application for handwriting expert.
what happened to that
That was turned down. That I have mentioned, my lord, if your lordship kindly. Next, here, this court reiterates, my lord, you'll find the last paragraph of the same page, that to challenge the LTIs of the executor of the said impugned deed of gift in their pleadings, the plaintiffs have also referred a deed of gift executed on 15 January 1999, previously executed said Nur Muhammad Sheikh, so as to seek expert opinion in respect of LTIs of the executor as appearing on the impugned deed of gift. So for the written statement on record concerned, the defendants contend that they have no knowledge of such deed. Suit record, particularly order number 31 dated 21st 2019, informs that the prayer of the plaintiffs are comparison LTI of the executor in the impugned deed with the LTIs of the executor in the said deed dated such and such has been rejected on contest on the reasons stated therein. Thereafter, by way of revision, the plaintiff did not take any further steps. So we have preferred this application was rejected. My lord, no. So for the purpose of admitted signature, my lord knows whether it is admitted or proved. If I can prove beyond a reasonable doubt before the court below that this signature belongs to that person,
how do you prove the document
I have to bring that person on the dock that whose favor the deed was executed.
we brought him
That is why the prayer was made.
prayer was made for handwriting
Handwriting expert. In the written statement, they have denied. Malakali, in the written statement,
in your if your handwriting expert was dismissed you could have first had it proved by some its author or whoever. Author could not be, but
the person
yes, you did not prove that document. So therefore, you cannot. It does not lie in your mouth to say that handwriting expert should be allowed. It is not an admitted document. Next step is you are rightly saying it had to be proved by someone. You did not do it either. So it was rightly rejected.
And the last one is the next portion. The execution has not been challenged by the person by whom it purports to have been executed. Last portion of this same page, my lord, and provides to section 68 of the Evidence Act. The contest court mentions. So these are the particular findings of the learned trial court for the purpose of holding that the deed was
Rightly, Mr. Where is the question of where is the substantial?
now I'm going to consider whether the mere registration implies that the due execution of the document. This is the next page your lordship will find.
It's your challenge. You have to show that the LTA was not proper. Did they prove the document in any manner?
It does not.
Did not.
It does not appear from the either of the records or any exhibit list. It is not mentioned regarding that document. But here, my lord, if you logically consider 114 C of the Evidence Act was considered that the official acts of the registration of the cost schedule impugned deed gifts had been performed lawfully. Moreover, according to this court, the stage of argument concerning the process of registration, impugned deed of gift is not sustainable because it is totally beyond their pleadings. My lord, Kali consider this aspect, whether the registration ipso facto makes a deed legal. If there is certain circumstances and privacy,
you have to then make out a case that it was not accepted during lifetime or something like that. You have not made out that case. You said it's
false personification. Therefore,
personification.
If the deed is
false personification, your case was at the time of execution or registration.
Execution itself. That is why LTI
failed to prove by any evidence. If your case was false, there could not be any false personification at the time of registration.
Yes, but in 2001, my lord,
2001 you have stated, not proved, dismissed your suit. You have not taken a point, the other point, that during lifetime it had to be accepted. That was not your case even. You're making out a new case in second appeal.
No, that case, but if you logically consider the deed, which is subject matter of dispute.
Your suit, you say your only case is that this deed is vitiated because it was vitiated by false personification. You failed to prove it. Suit dismissed. It's not their suit relying on that deed.
Only these are the
second appeal. These are not second appeal matters. Matters to be admitted in second. First appeal you could have understood.
Because I have taken that point, order under section 105 with the appellate court. Appellate court also considering that way that revision if the but
105 is there available.
105 is there, that was challenged.
Independently
Be as it may, my lord, if I do not prove any document to that extent, whether I can avail
not admitted, it's evident from the circumstances. The present appeal has been preferred by the plaintiff. Yes. The present appeal has been preferred by the plaintiff in a suit for declaration that Hibanama executed in favor of the defendant stroke respondents was void, comma, being vitiated by false personification, comma, and consequential reliefs. For sub next para, both the courts below dismissed the suit of the plaintiff on the ground that the plaintiff case had not been proved. For sub next para, learned counsel appearing for the plaintiff stroke appellant submits that both the courts below failed to consider the consequences of a deed of gift by way of Hibanama having not been accepted during the lifetime of the donor. For sub it is submitted that both the courts proceeded primarily on the premise that the deed of gift that the registration of the that the deed of gift in favor of the defendant stroke respondents was registered, comma, without considering the other relevant considerations in case of a Hibanama. For sub next para, learned counsel next submits that the learned trial judge erroneously dismissed the application of the plaintiff stroke appellants for appointment of handwriting expert to examine the authenticity of the left thumb impressions within bracket LTI of the alleged donor Nur Muhammad on the impugned Hiba executed in the year 2001 in favor of the defendant stroke respondents. Pushup, it is argued that under section 105 of the Code of Civil Procedure, comma, even if no challenge was preferred at the relevant stage, comma, interlocutory orders passed in a suit may be challenged on the ground of error or illegality stroke irregularity at the in the appeal preferred against the final decree passed in a suit, comma, if such orders have a vital bearing on the outcome of the suit. Full stop. Next para. However, comma, we are unable to accept the contentions of the appellants for the following reasons. Colon, niche. The courts below came to concurrent findings that the plaintiffs' appellants have failed to prove their case of false personification of the donor Nur Muhammad Sheikh at the time of execution of the impugned Hibanama in 2001 in favor of the defendant stroke respondents. Full stop. Next para. The same being a concurrent finding of fact and a matter of evidence, comma, there is no scope of reappreciation of such evidence by the second appellate court. Full stop. Next para. Secondly, comma, the challenge sought to be thrown against the order whereby the application of the plaintiff stroke appellants were for appointment of handwriting expert was rejected cannot also be entertained for the simple reason that it is explicit from the judgment of the court of the trial of the courts below that the document of 1999, comma, the signature on which was sought to be compared by the handwriting expert with the impugned deed, comma, was not an admitted document. Full stop. Next para. Secondly, comma, the said document, the signature on the said document was also not independently proved by the plaintiff's appellants by any witness. Full stop. Thus, comma, we do not find any infirmity or illegality and stroke or irregularity or error in the order of the learned trial court dismissing the application for appointment of handwriting expert. Full stop. Next para. Insofar as the registration of the Hibanama in favor of the defendant's appellants being subsequent to the registration of the purported Hibanama executed in favor of the plaintiff's appellants, comma, since the plaintiff's Hibanama was executed much later than the defendant's Hibanama by the donor, comma, by operation of section 47 of the Registration Act, comma, the date of the execution, the relevant date for consideration of which deed prevails relates back to the date of execution of the deed upon registration. Full stop. Thus, comma, even if a deed is executed earlier but registered later, comma, the earlier executed deed would prevail over a deed which is executed later but registered earlier. Full stop. Going by such premise as well, comma, the plaintiffs have failed to make out a case to dislodge the Hibanama in favor of the defendant's defendant's respondents which have been impugned in the suit. Full stop. Next para. In view of the above, comma, we do not find any illegality in the orders of the courts below. Full stop. That apart, comma, in view of the concurrent findings of both the courts to the effect that the plaintiffs have failed to prove their case of false personation in respect of the impugned deed, comma, we do not there is no substantial question of law involved in the appeal. Full stop. Accordingly, SAT 196 of 2025 is dismissed under order for Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 also stands dismissed, no arrest to cost. Urgent certificate.
In my lord, I am for the defendant appellant. Lord, my appeal for
What is the defect in this?
my defect, my lord, the learned judge's name was not there.
Do you know the name? You can
No, I do not know. That is the difficulty because may I, my lord?
No, you have given the name.
No, I have given the trial court's judge's
Oh, the appeal court's name. Is it not there in the judgment?
No, it is not there in the judgment because the section, my section 5 was dismissed and challenging.
You could have
that-
asked your counterpart in the trial court. He or she would have told you. Could have just asked the advocate to send the plea to you.
I will ask.
Do that
and
by tomorrow.
by tomorrow I will.
Let us hear the
And
Yes.
my lord, kindly come to the appeal court judgment. Lord,
Yes.
paragraph T.
First,
It
tell us
ap-
you are the plaintiff in the suit.
I am the defendant
Suit for
for eviction.
on
On
Ground?
they ground, my lord, they said I am a trespasser, but at that they have sent me section 6(4) notice. That
So
means
therefore they said
admitted that I am a tenant. So that plea does not
suit was decreed on the ground of trespass.
trespass. And my lord, kindly come to the issue number 3. It was found that the property is a thika property. So if it is a thika property, then civil court is the suit is not itself maintainable because civil court has no jurisdiction.
Good points. But let us see, section 5 has been dismissed.
Section 5 has been dismissed.
What was the delay?
Delay because of, my lord, learned advocates.
What was the delay?
300 days, my lord.
The same advocates filed the appeal.
No.
Then you have to.
Kindly come to.
Advocate's fault is a very easy excuse.
No, my lord, I am a day laborer. He do not inform me about the fate of the
That
case.
borne out by affidavit.
No, I have not filed any affidavit because there is no stay application. I have prepared, but it was not filed.
Section 5?
No.
Here there is no.
My lord, may I read?
Day laborer, where do we get that?
Day laborer, I have been informed.
Have you got any papers of the trial court? Let us see any affidavit in the trial court. You are only armed with your copy of the memo, nothing else. How did you draft the appeal? Where is the rest of your brief?
My lord.
My lord. What, my lord? See your trial court documents whether there is in pleading any affidavit.
So there is no.
If you see business, you are out of court in the affidavit.
My lord, I am seeing. In the
Even
written
the plaints are
statement,
supported by affidavit.
written statement.
Oh, sorry, your written statement, yes. Written statement, affidavit, or any other objection to some or application, or even your section 5 before the appeal court. And also give us a copy of his section 5.
Section 5.
Will-
And now, my lord.
Yes, before the appeal court, the section.
Section 5, I have only one copy. Grateful, my lord.
Section 5 is dismissed হয়েছে এগুলো তো generally এখন অবশ্যই দেখতেছেই ওই This appeal will be heard on the following substantial question of law: whether the learned first appellate court substantially erred in law in overlooking the fact that the appellant is a day labor, as borne out from the affidavit supporting the condonation application filed before the first appellate court, and a layman, and as such, was justified in pleading that he was not properly advised to file the title appeal within time. Who's up next? Whether the impugned judgment of the first appellate court is vitiated by substantial error of law, inasmuch as applicability of the principles governing adjudication of condonation applications are concerned. Third, whether the learned first appellate court substantially erred in law in proceeding in a perverse manner to dismiss the condonation application of the appellant without discussing at length the averments made therein. This much. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books, requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Grateful.
After I had the liberty to mention the appeal before the appropriate single bench, appropriate learned single judge having determination for the purpose of inclusion in the list as and when the appeal is ready for hearing. You file your section 5 application immediately, otherwise you'll be evicted before you before your appeal is heard. Why didn't you file a stay application? File a stay application immediately. They must be executing the decree by now.
My lord. But may I get back my appeal code section 5 copy?
No, but we have referred to that. That is the only ground.
Only,
Don't you have another copy?
no. May I take the photo?
Now, Farida, immediately.
My
For
lord.
the court rises.
My lord, my lord.
If the court rises, you're gone.
No, I will.
Yes. Next. Yes.
Your Lordship, I am for the appellant. Your Lordship, I have filed a suit for declaration
Yes.
and for cancellation of the gift deed, along with an application.
Just give us half a minute. Just give us half a
Yes,
minute,
Your
please.
Lordship.
Valuation of the suit is 1,04,000.
Your Lordship.
So appeal is maintainable for the district court, not before this court. 1,50,000.
Your
Above 1,50,000, this court. You have to prefer an appeal before the district court, not before the high court.
Okay.
It's undervalued. Above 1,50,000, we have jurisdiction. We'll give you liberty. We'll dismiss the appeal on ground of jurisdiction. We'll give you liberty to file the appeal before the district court. And you'll take back the certified copy, take proper advice from a clerk who works in the appellate side, civil appellate side,
Yes.
in civil matters.
Yes.
Take an advice from a clerk or if you're a learned advocate, better, much better. It transpires from the additional stamp report that the valuation of the appeal and the suit from which the same arises is 1,04,000. 1,00,400 oblique dash. Full stop. Have you got a copy of the plaint?
Yes, Your Lordship.
Check up whether that was the valuation. Yes, that was the valuation. For the next para, we also find from the plaint annexed to the connected application that the same was the valuation, that the valuation of the suit was the same. Full stop. Hence, this court does not have pecuniary jurisdiction to entertain the appeal. Full stop. Accordingly, FMAT 405 of 2025 and FMAT 405 of 2025 is dismissed due to lack of pecuniary jurisdiction, with liberty to the appellant to prefer an appeal against the impugned order before the appropriate district court having jurisdiction. Full stop. Next para. If such an appeal is filed within a reasonable period, the time spent in the appeal pending before this court shall be taken into consideration within the contemplation of Section 14 of the Limitation Act 1963. Full stop. Next para. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order from the department upon furnishing a photocopy of the same for the records. Can 1 of 2025 is consequentially disposed of, no rest of us. Please take back the certified copy from the department. Take assistance from somebody. Next.
My lord, I'm for the appellant, my lord.
Apart from section delay, is there any other defect?
Yes, my lord, kindly. There is, according to my lord, there is no delay. My lord, kindly see for a moment.
Let's just check up what are the other defects. There are other defects also pointed out.
Yes, my lord.
In absence of full cost title certificate copy.
First defect, my lord, the
respondent number 1, Sharafat Khan, has not been made a party.
Yes, my lord, I'm giving the order. It is struck off. Name has been struck off.
Oh, already struck out.
Struck off. The order is with me. My lord, kindly see the first point is Section 5.
Yes, first is 26 days delay.
Yes, my lord, the order passed 29th August 2025. Then, my lord, I have filed on 17/9 2025.
29th August.
My lord, I have
City Civil Code. What is the limitation now?
30 days. Within 30 days, I have filed, my lord.
Oh, within 30 days.
I have filed. But the my lord justice has been already transferred. Therefore, the department.
Give us half a minute, Mr. Mishra. We'll just calculate ourselves.
My
29th August, so 2 days there. 2 8 10 Yes, it is in time.
Yes, ma'am.
In time. দেখো 29 এখানে 2 দিন গেল আচ্ছা
Since the my lord justice
8 তারিখে করেছে 2 আর 8 এ 10 দিন গেল ওখানে
transfer ছিল
10 দিন গেল তারপর পেল 10 তারিখে তাহলে আরো 20 দিন পাবে 30 দিন হলে 10 দিন আগে গেছে তার মানে 30 এর মধ্যে করতে হবে 17 করে দিয়েছে yes yes who was transferred
my lord justice high court justice transferred, therefore the matter has not been registered. Subsequently I went to the department, he supplied me the number.
high court justice transferred means
কি ছিল কোন judge ছিল?
what high court justice
I have mentioned, I have handed over the 2 documents, my lord kindly.
no, you don't know what high court justice transferred how, what does it have to do with it
I have filed mentioning there the my lord justice division bench judges names are there. Kindly see these documents I have handed over just now.
yes
My lord justice so mentioned.
no, this computer sheet carries my name and justice Uday
Yes,
Kumar
they are subsequently I have
my name has been erroneously spelled in the computer sheet
yes.
so this should be dismissed on that ground
No, my lord.
no
Kindly, I have handed over 2 documents to the number documents.
কি document
Why do I want
what is the other defect
Other defect, my lord, the first name of the defendant.
yes yes what about the first defendant respondent
This is the order, my lord.
Sarafat Khan's name is there in the certificate copy
Yes. The mistake of the learned court, my lord. This is the order.
well two defects have been pointed out by the stamp reporter, by the additional stamp reporter, full stop. Insofar as the first is concerned, comma, it has been reported that there is a delay of 26 days in preferring the appeal. Full stop. However, comma, we find from the certified copy of the same that the impugned order was passed on August 29, 2025. Full stop. Certified copy, therefore, was applied on September 8, 2025. Full stop. The requisites were notified on September 10, 2025, on which date those were deposited and the certified copy was made ready for hearing. Full stop. Next para, the appeal was filed on September 17, 2025, comma, that is well within the limitation period of 30 days for preferring the appeal. Full stop. Thus, comma, the appeal be treated to be filed within time. Full stop. Next para, as regards the second defect, comma, although in the cover page of the certified copy of the impugned order, the name of one Sarafat Khan appears as defendant number 1, comma, learned counsel for the appellant hands over a copy of an order dated August 12, 2024, passed in the connected suit, wherefrom it is evident that the defendant numbers 1 and 2 within bracket including defendant number 1 Sarafat Khan, comma, had died during pendency of the suit. Full stop. It was further recorded that the suit has abated against the defendant numbers 1 and 2 and shall proceed against the surviving defendants. Full stop. Hence, comma, the second defect pointed out by the additional stamp reporter may also be ignored. What is the appeal about now?
My lord, kindly see the impugned order. The plaintiff is returned back the suit for eviction on the ground of trespasser. The framing of issues was date been fixed up, and the show moto, the learned court directed the return back the plaintiff.
Was a question raised regarding walk-up property? It has been returned.
Returned as because the walk-up property
Tribunal has
go
jurisdiction.
to the tribunal.
What is the plaint? You should have annexed the plaint. You have not filed any connected application.
No, my lord, no kind.
Oh, suit has been
returned.
No application for stay of operation.
My lord,
If order is not stayed, it will go to the tribunal.
My lord, kindly see for the judgment, Supreme Court judgment for a moment. My lord, kindly see.
We'll come to Supreme Court judgment later. We have not filed any stay application.
No, I have not filed.
Even if it is admitted, what will be the use? It will be transferred before the appeal is heard. What is this? Anis Fatma?
Yes.
Which judge?
M.R. Lodha.
M.R. Lodha?
Lodha. My lord, kindly see.
Walk-up matter M.R. Lodha?
Relevant paragraph, my lord, the 17th.
চিন্তা করুন
বলে দিলাম কোথায় লিখলে
Sir, Mr. R.M. Lodha is the judge. of the Supreme Court, the first judge.
Answer.
17, 18.
17 or 18, the relevant paragraph, my lord.
Where is the plaint? First give the plaint.
I have not
Consider
annexed.
just-
I have not annexed.
Excellent. Come back tomorrow.
Tomorrow, my lord.
Since learned counsel for the appellant is not equipped with the plaint of the suit, comma, which is relevant for the present consideration, comma, let the matter stand adjourned for the day. Push of the appellant shall furnish a copy of the plaint filed in the suit, as well as copies of the Order 7 Rule 10 application and written objection thereto, comma, if any, at the time when the matter is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. এই বইটা ফেলে দিন। Should you give it tomorrow or day after?
My lord, tomorrow.
Tomorrow.
Or keep it on Monday, my lord. Keep it on Monday.
তাহলে ওটা যেটা বললাম tomorrow adjourn for the day না করে adjourn till December 15, 2025. Bring 2 copies at least, Mr.
Yes,
Mishra,
my lord.
for each of us.
Lord, the plaintiff, Lord, is
Could I
the
appear for
appellant
the
before your
respondent on
lordship.
caveat?
Lord, there is a section 5, Lord, unfortunately, that is not before your lordship today. Lord, it's
11 days
recorded.
delay, your lordship can allow that. Lord, I have
Lord,
got no objection.
takes it up tomorrow, Lord, in that case, the you will be there.
11 দিনের ডিলে আমি তো বলছি তুই কর appear question list এ yes it is appearing appearing তো কি লিখেছেন আপনি লিখেছেন কেন
ক্যান কত
You have filed a suit wrongly.
Not
You have
that.
filed a suit seeking mandatory injunction that they may vacate the premises, and in the same breath you are asking for injunction so that they may not disturb your ingress and egress.
Lord, with respect to the occupancy of that room, then that I can understand whatever is there is there. the
Schedule A and
office
B,
can
the
be-
entire schedules.
But the problem is with respect to Lord G, the F.
Iron
papers- the papers are there.
chest is lying on the outside of the premises.
It's inside that room. It's inside that.
I have never seen such a ridiculous plaint, Mr. Kormkar, in my little life, which is not so little. A and B scheduled property is the immovable property itself, the house, including the flat. A is the house, B is the flat. You seek their eviction from A and B, and you say that regarding iron chest which is inside, that they'll hand over the keys to you.
room সেটা just বুঝতে
Any input you have to, you can tell us. Anything to better your case? We don't find anything in your case. Your plaint should be returned, rejected, sorry. Vexatious, whatever was used in that 1977 Supreme Court. The rest of the language.
This is after all a trust property, Lord. If the plaint is not also happily drafted in that
Happily,
case,
what happiness do you deserve?
the court will try to secure not the trust property.
No, court doesn't have any other word. Your plaint is not happily drafted, and court will secure that you are protected. Sorry, sir.
It's a trust property, Lord. Kindly considers that.
Completely based on mistrust against your own son.
Lord,
son, we are not prejudiced. We are not prejudiced with son may have a quarrel against the father. We don't have anything to do with that, but no.
No, the question is whether Lord, they claim their right to that will. The question is whether Lord, today they can claim a
Kormkar, we fail to understand
what
completely.
is falling from your
What sort of injunction are you expecting?
Lord, at least an access to the Almirah so that I can have those papers.
That will be
They do
prejudging
not
the
have any
suit
right.
itself.
Prima facie, they do not have any
That
right.
will be prejudging the suit. That is a relief you seek in the suit.
No, the issue is only with respect to the papers. Nothing more than that.
No papers.
Lord, kindly consider this aspect. Not without the papers, I am unable to run.
Sorry, Mr. Kormkar.
Prima facie, your lordship would find from the Lord trust deed itself, Lord, they do not have a right.
The present appeal arises out of an order whereby both parties were directed to maintain status quo in respect of possession and enjoyment of the suit property as described in the plaint. Full stop. Learned counsel, Mr. Chatterjee's name will be recorded also. He's there.
He's there.
Learned senior counsel appearing for the plaintiff stroke appellants submits that the appellant number 2 is the surviving trustee of the appellant number 1 trust. Full stop. The defendant stroke respondent comma who is your son? All of them?
No.
Somodip.
Your wife and sons?
No.
No, wife.
First is the sister, and Lord, the second is the sister's son, and third is Lord his.
Third is my son. Second is sister's son, and first is the sister.
Against the defendants stroke respondents who are respectively the sister, sister's son and own son of the plaintiff stroke appellant number 2. Full stop. Next para. Learned senior counsel submits that in view of the plaintiff's stroke appellants not being in possession of the suit premises, the learned trial judge, by directing both parties to maintain status quo in respect of the suit property, has virtually ousted the plaintiffs from the property, which is contrary to the prayer made in the injunction application. Full stop. In the temporary injunction application, the plaintiff stroke appellants prayed for an order of injunction restraining the respondents and their men and agents as well as associates from creating any obstruction and or embargo to the appellant number 2 to enter into the suit premises described in Schedule A. Full stop. Next para. However, a bare perusal of the plaint, in conjunction with the injunction application shows that the relief sought in the temporary injunction application was not maintainable at all. Full stop. In the same breath, comma, in prayer small g within bracket of the plaint, comma, the plaintiffs stroke appellants seek mandatory injunction directing the defendants to vacate the suit property mentioned in Schedule A and B, which are respectively the entire property and a flat therein, comma, while on the other hand, an injunction has been sought restraining the defendants from dealing with an iron chest lying inside the said premises. Full stop. Next para. It is a contradiction in terms that while admittedly the plaintiffs to appellants are not in possession of the immovable property within which the Schedule C chest, iron chest is located, comma, while on the other, comma, an injunction is sought seeking the defendants to hand over the said chest in favor of the plaintiffs. Full stop. Next para. In any event, comma, we do not find any illegality in the impugned order whereby the learned trial judge, comma, despite the above gross discrepancies in the suit, comma, granted an order of status quo restraining both parties from altering the possession and enjoyment of the property. Yes, suit property, which would protect the interest of both the parties. Full stop. Accordingly, there is no scope of interference. Hence, FMAT 452 of 2025 is dismissed under Order of Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, can 1 of 2025 stands dismissed as well without any orders to cost. Thank you.
Only one thing, item number 14 is mine. If your lordship has 1 minute or 2 minutes time, otherwise.
So we have another bench.
I know, my lord. The only difficulty, my lord, if it can be taken up tomorrow, because there is some urgency in the matter.
No.
But I was waiting, my lord,